Good morning. I'm Judge Tammy Long Hayward. This is the Clayton County State Court. This is courtroom 304. This is the civil motions and hearing calendar for October 30, 2024, 11 a.m. I'm going to call the calendar. If you are present and ready for the calendar, please announce. First Key Homes LLC versus a debt player and all other occupants.
Good afternoon, Your Honor. Luke Bolton,
Present.
the plaintiff.
Okay.
Present.
Bolden. All right.
Yes,
Who
ma'am.
else is present?
Johnson.
Okay, Mr. Johnson, you live in the property also?
No, ma'am. I'm sorry. I'm a different property. I'm sorry. I thought you meant everybody. I'm sorry, ma'am.
Okay. Miss Player.
Yes, ma'am.
Okay. And
My husband is on as well, Ricky Player.
And Your Honor, I've got a representative, Ms. King.
okay. All right. And is someone here on Otonio Soto Morales versus Terrence Jones? All right, so we'll go forward with the first case and then I'll call the rest of the calendar. First Key Homes LLC versus Audette Player. Mr. Bolden. Hello?
Yes, Your Honor.
All right. Are you ready to present?
Yes, Your Honor.
So, am I mistaken, or was the answer filed 11 days after the service, after the case was filed, after service?
Your Honor, that would be something that I've not been able to confirm. I'm not able to confirm at this time. If Your Honor is seeing, service that way.
Do you know the date it was served, Mr. Bolden?
I do not have the affidavit of service, no, ma'am.
All right.
You want me to check it for you, Jim?
I can work on it.
Yeah, Miss Val, because I can't legally proceed if service if the answer was filed after it becomes a default automatically by operation of law.
It appears that it was transferred from magistrate court on March 26th. It's stating that the sheriff entry of service was 10-6 from magistrate, and there was an answer filed by REM Player and Ardette Player on March 26, 2024, along with a counterclaim. So let me get a copy of the service from the clerks.
All right, thank you.
I don't have one either, Your Honor. Thank you, Madam Clerk.
Okay, so I'm checking because this case, is my understanding, was transferred from magistrate court to state court the rule of sevens applies in an eviction case where once it's served, the defendant has 7 days to answer. And then it has to be put on a calendar. But if you haven't answered within the 7 days, then I can't legally hear the case as anything but a default, because the law states that if it's not filed within 7 days after service, I only have two options. If service was personal, I can grant judgment and possession. If service was tack and mail, I can only grant possession. So, 1 second.
Your Honor. Ms. King?
Yes, Mr. Bolden?
Yeah, I pulled up the underlying service and it looks like the service was September the 18th, 2023. And it looks like that, it looks like
Oh,
the response is filed the next day, the
all right,
19th.
so, because the sheriff's entry should have been filed the day of or the day after service. It was not. It was not filed until October 6th, but if she was served on the 18th and she filed on the 19th, then she's within the service period. So, all right. Thank you.
Yes, thank you. Sorry about that.
No, no problem. All right. So, First Key Homes, do you have someone who's going to present the evidence on your behalf? Do you have a witness?
Yes, Ms. King is here. Ms. King,
Okay,
can you turn your video on?
Oh, yeah, sorry.
I'm gonna need you to screen share some exhibits, okay?
Okay, give me 1 second.
All right, raise your right hand for me, Ms. King. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes.
All right, you could put your hand down. Your witness, Mr. Bolden. Ms. Player, once Mr. Bolden has presented the evidence on behalf of his client, then you'll have the opportunity to ask any questions that you may have of the witnesses that he presents, or to present any evidence with respect to your answer, or counterclaim. Okay.
Okay,
All right.
Ms. King, we're gonna start first with Plaintiff's Exhibit 1, which I've already submitted to the court, which is gonna be the lease.
Okay. Let me pull that up.
Pull that up. And while you're doing that, if you would just introduce yourself to the court and let the judge know your association or affiliation with First Key Homes.
Yeah, I'm Talia. I'm a property manager with First Key.
Okay. And are all the documents we're going to discuss today, kept in the ordinary course of business with First Key Homes?
Yes.
And you have access to those records and have personal knowledge of those records based upon your review of those records. Is that accurate?
Yes.
Okay.
I got the lease right here. Give me 1 second. Okay. Want me to share my screen, you said?
Mm-hmm.
Okay. So I'll share this one. This is the lease that we have in file.
Okay, and specifically, is that the lease in connection with Audette Player and Ricky Player?
Yes, their names are.
They're on page 2?
Yeah, right here.
Okay. Specifically for the address located at 10959 Hondell Court, Hampton, Georgia 30228.
Yes, sir.
And is that the subject premises that we are seeking possession of today?
Yes, sir.
Is that located in Clayton County, Georgia?
Yes.
Okay, and if you would, what is the term of this lease? I believe you'll see it there at the bottom of page 1.
The term for this one looks like 8/31/2020. This is just for the rent. 8/31/2020 to 9/7/2021.
Okay, the version that I have, the term commences on September the 8th, 2022. Are you able to pull that one?
Yeah, let me look for it. Give me 1 second. You said it started in 2022?
Yes,
Okay.
September the 8th. There we go.
Yeah, there we go. My apologies.
There you go. Okay, perfect. So the term of this lease is 9/8/2022 to 9/11/2023. Has there been any other renewals or contracts or leases between the parties since that time?
I don't believe so.
Okay, and is First Key Homes, they were the managing agent for this property. Is that accurate or not?
Yes, that is.
Okay. And if you would scroll down to the end of the lease and just show the court the signatures and let the court know when this lease was signed.
So the first set of signatures we have for the lease in general says it was signed by both residents on June 17th, 2022, and it was countersigned by us on June 21st, 2022.
Okay, thank you very much. And what is the base amount per rent per month for rent at this property?
That would be $2035.
$2,035 to be specific.
Yes, sir.
Okay, and I'm kind of catching you off guard here a little bit, but do you know when the last time that rent was paid?
I can check the ledger. It's been well over, I think, months.
Yeah, let's pull the ledger up.
I'll put this over here. Okay, this is the ledger as of today. The last time any payment was received was on December 1st, 2022 in the amount of $4,445.
Okay, and that left a remaining balance of 2310.89.
Yes, sir.
After that payment.
Mhm.
Okay, and so what is the total amount that we are seeking today based upon that document? And this document is the ledger of the account for the address at 10959 Honda Court in Hampton, Georgia. Is that correct?
Yes, sir.
Involving Audette Player and Ricky Player, the defendants here today?
Yes.
Okay. What is in this document, was this document kept in the ordinary course of business
Yes, it is.
with First Key Homes? Okay. What is the total amount we're asking the court to grant today as a monetary judgment?
The total amount due in the ledger today, including November's rent, is $64,696.
What would be the amount just through today?
Through today, which
Yeah.
I guess $62,000, $62,086.
$62,086. Okay. And this ledger includes additional charges such as utilities in the ordinary course of business. Is that
Yes.
correct?
Yes, sir.
Such as electric, water, stormwater, insurance non-compliance fees, and month-to-month fees. Is that accurate?
Yes, sir.
Okay, and are those fees that I just listed set forth in the lease agreement between the parties?
Yes.
Okay. So, Your Honor, this would be Plaintiff's Exhibit 2. We'll go ahead and move to admit Plaintiff's Exhibits 1 and 2, the lease and the ledger.
I have a question.
I'm sorry, was that
Oh.
Your Honor, was that
Yeah.
you?
It was me. I have a question.
Okay.
So my question is, the amount owed, the first amount was $64,696. But when you said through today, changed to $62,086. What's the $2,000 or thereabouts? What's the difference?
So the original figure, the 64,796, that includes November's rent because November's rent's already posted. But through today, October 30th, it's 62,086.
All righty. That was my concern. All right, thank you.
Okay.
All right, so Miss Player, Mr. Player, the plaintiffs have offered their exhibits for entry into the court's record. Do you have any objection to anything that's been testified to with respect to these records?
I do object, Your Honor. And I do have questions. So should I object and go with why I object first, or should I ask my questions first?
Okay, so is your objection that the records are not the records that were kept in the normal course of business, not specifically as to whether they're correct as you see them to be, but do you dispute that these records were kept as business records by your rental agent?
I object that the amount is wrong for
Okay.
the amount
That's
that was
different.
paid in December. Okay.
All right, so, but these being records that were kept in the normal course of business, we can
Yes,
talk
that is
about.
correct.
Okay, all right, so that exhibits 1 and 2 will be admitted with the objection noted that the defendants believe that the amounts attested to in the records may not be correct. Okay,
Yeah,
all right,
that's
so exhibits 1 and 2 will be admitted. All
Okay.
right.
Okay, Ms. King, if you would please pull up the demand notice letter.
Okay. 1 second.
And that was, it would be dated August the 8th.
August 8th.
Yes, ma'am.
What year? Just so I know.
2023.
Okay, it's just one right here.
Okay, do you recognize this document, and can you please identify it and describe it for the court?
Yes, this is a demand letter. It's the demand of rent for non-payment. This is what we send to residents before we file.
And this document has been kept in the ordinary course of business with First Key Homes.
Yes, sir.
And when you said this would be the letter we sent out for non-payment, specifically, was this letter sent out to the residents at 10959 Hondle Court, Hampton, Georgia 30228, on or about August the 8th, 2023?
Yes, sir.
It would be the ordinary course of business and practice of First Key Homes these would be automatically generated when a tenant gets behind and sent out to the tenants. Is that accurate?
Yes, sir.
Okay, and in this instance, at the time when this letter was sent out, how does First Key send these notices out?
It's through certified mail, so it goes straight to the property.
Certified mail. And at the time when this was sent out, what was the balance that was owed as reflected on the account at that time and in the letter?
It looks like it was $21,843.25.
And again, that was not paid, and no monies have been accepted from First Key since that time period. Is that accurate?
Correct.
Okay. Do your records show there was any attempt to make that payment in full?
No.
And subsequent to this letter, it indicates that there's 3 days for them to pay in full. Is that accurate?
Yes.
And subsequent to this letter going out, the tenant's not paying in full, is when First Key Homes, through its attorneys, filed the instant claim, dispossessory action, seeking monetary damages in possession of the subject property. Is that accurate?
Yes, sir.
Okay, Your Honor, plaintiff would move to admit the demand letter notice on the screen as plaintiff's exhibit 3.
Any objection to the demand letter, Ms. Player?
No objection, other than I did never received that certified mail. And if so, I would like to see a signature for a receiver for certified mail, please.
Okay, so Exhibit 3, the demand letter will be admitted with the objections noted from Ms. Player.
Okay. Lastly, Ms. King, the crux of the tenant's answer in this case essentially surrounds, and I don't want to misquote it, but essentially surrounds the belief that there should have been some kind of credit applied to the account. Can you pull up and this was already duly admitted, attached as an exhibit, Your Honor, to the tenant's answer in this case. But Ms. King, if you could pull up the ticket confirmation number of the credit that was at issue during that time.
The confirmation number?
Well, there's a confirmation letter that I have here that it says that, a credit was issued, ticket number 1262126.
Okay, let me pull that up. Give me 1 second. Count that number one more time. I'm sorry.
It's 1262126.
1262126. Okay. I got it. Give me 1 second. Can y'all see that?
Yes, ma'am.
Okay.
Okay. And essentially, and I may be catching you off guard a little bit, but this document that we're looking at, can you just describe it for the court as far as what this is, as far as internal?
So it's just a download of a ticket from Zendesk. Zendesk is the platform we use to communicate through email with our residents. So this is just the summary of that, and it shows everything sent and received.
Okay. And so in this instance, would this represent the credit that Miss Player is referencing that needed to be issued in her answer? Is that what this involves?
Yes, I believe this includes the confirmation that we issued credit. Review process.
So this is all these communications are between First Key Homes and Miss Player. Is that accurate or not?
Yes.
Okay. So if you would just close this window and pull the ledger back up.
Okay.
And once that's open, would you please share your screen on or about the month of September 2003?
Okay. 2023.
2023, yes.
That would be right here.
Okay. Are you able to zoom in a little bit at all?
I might have to download it to that, and I can't.
It's okay. Your Honor, are you able to see this okay?
Yes.
Okay. And if you would, Ms. King, can you please read the itemized line for September 21st, 2023?
Yeah, this was it says concession for multiple maintenance issues in the laundry room, replacing the carpet. All AMG was removed and the area was dry. Has the corresponding work order numbers. This was approved by our regional VP, and then it has the ticket that we submitted to accounts receivable to put it in.
And what was the amount of the concession that was issued?
$2,035, so 1 month's worth of rent.
Okay, 1 month free rent. And what does all AMG was removed stand for? Do you know?
AMG is what we call organic growth. So any
Okay.
organic growth that comes from water damage.
Okay, perfect. Are there any outstanding work orders
Not that I
placed by
saw.
Mr. or Mrs. Player in connection with this property?
Not that I saw, but I can pull them back up just for that confirmation. I'm not seeing any that are open.
Okay. Your Honor, we would move to admit as plaintiff's exhibit 4, the internal work order that seems to be the underlying basis of this dispute. I did not send that to the court. I'll be glad to do that.
All right. Any objections? Ms. Player?
No objection, other than the fact that there are open work orders that have not been filled, because of course we are not under lease and, they have not come to fix. So I do object to that, and I object to that being the amount of the credit as well. So I don't know how you want to word that, but that is not the amount of the credit, $2,000. So I guess I'll have my time to speak.
All right.
So Your Honor, again, just to recap, the plaintiff is seeking a writ of possession to issue within 7 days. And the total balance after that 7 days is that first figure we gave you, the $64,696. Ms. King, is that accurate?
Yes.
That figure is accurate?
Yes, sir.
64,696. Okay.
Yeah.
Nothing further, Your Honor.
Well, there's one thing further. Y'all haven't told me whether they're still in possession of the property or whether we're just arguing about money.
Yes, I'm sorry, Ms. King. As far as you're aware, is the property still being occupied by the tenants?
Yes.
They're still in possession?
Yes.
Okay. That's
All
all.
right. All right, Ms. Player, did you have any questions for Ms. King?
Yeah, I have several questions for Ms. King. How you doing, Ms. King?
I'm good. How are you?
Well, can I ask you when you started working for First Key Homes, please?
My first day was, I believe it was September 23rd, so last month.
Oh, you just started last month. Okay, so
Yeah.
September 23rd, 24. Okay, so are you is Alyssa Hayes, which is the property manager, is she still the property manager of 10959 Honda Court?
We don't have, we have property managers. We don't have specific portfolios, so we're not assigned to a specific property. But she is still one of the property managers with us, yes.
Okay, do you know if Simone Kennesaw, Kennebrew is still a manager at First Key Homes?
Yes, ma'am, she is.
Yeah.
Okay. Okay, I'm sorry. I thought I heard something. I'm sorry. So are you aware of the black mold poisoning that was found in my home, in my daughter's room? Are you aware of?
Your Honor, I'm going to object to the question. There's no foundation for that.
I'm asking based off of the
Hold on,
evidence that you supported.
Mr. Bolden, we just have a discussion about AMG, meaning that there was an organic, something organic found that was caused by water?
Yes. Yes, Your Honor.
Seems her question is valid based on the testimony posed by Ms. King.
Well, there wasn't anything said about a black mold.
Well, AMG and
organic
caused by water by any other term is mold. It might not be black mold, but you telling me that it's not mold that we're talking about?
No, I'm not saying that. I'm not at all. I'm suggesting
It's a
that
reasonable
wasn't anything
inference
brought
from
up.
the testimony given.
Okay.
All right, go ahead, ma'am.
Okay, so I'm asking, are you aware of the black mold poisoning that was found in my daughter's, I'm sorry,
Sorry.
in the walls, in the floors of my daughter's room at 10959 Hondo Court?
Yes, I was aware of the AMG
Okay.
issue there.
And were you aware that we were asked to bring in all of our supporting evidence to you and your legal team at the corporate office?
Yes.
Okay. So based on the information that you presented through the emails that you presented, and you have emails that look like my emails, and so those are the ones that I printed out. So
Okay.
based off of what you showed in the conversation, did you see an acknowledgement that they were working to give me the credit for my daughter's medical bills and for punitive damages?
Yes, the credit you requested.
Okay.
Yes.
So also, I have another question for you.
Okay.
Based off of your testimony, and you said that in December that I paid an amount of $4,000 and there was a balance left of $6,000.
I'll go back up to that.
Yeah, it was in the ledger. I think you said I owed $6,000 after paying 4,000 something.
You paid $4,445, and what was left over was $2,310.89 once that was applied.
So it's like late fee, utility fee, and some other fee. Okay. So you're saying I owe $2,000 after the payment was applied, and that looks like December the 1st. There was $2,000. Okay. So then is it accurate then by May 11th that by that time I owed 10,000, let's see, $10,175 by May 11th? Would that be accurate?
2023 or 2022?
2023, I think, yeah, 2023.
In May of 2023, I don't see anything specifically for the 11th. I have
Well,
entries
on
for
or around.
yeah, so around like the 6th, it was $14,564.45.
Okay, that I owe. Okay, so is it also true that you guys filed eviction at that time for the amount owed that's filed with the court for $10,175?
I'd have to go back. I know there was one filing before this one, so
It
that's
was,
what
yeah, that's the one I'm referring to. So it's the date of, it says the date you guys filed it would be May 3rd, 2023. That might be why it's less than the 14,000 because it shows $10,175.
Gotcha.
So
Okay.
and so are you aware that you guys voluntarily dismissed that and said that you filed it in error?
Yes, ma'am.
Okay. So based off of the evidence, and then if it was filed in error, then does that mean that I owe the 10,000? I'm just trying to figure out because it said that it was a voluntary dismissal. Now comes the above named plaintiff and hereby voluntary dismisses the above matter against the defendant without prejudice filed in error this day of 5/11/2023. Is that not correct?
Was it dismissed? Yes, it was dismissed.
It was dismissed and it was noted that you guys said that you filed it in error.
Your
Okay,
Honor,
so I
yeah,
just
we
wanted to
stipulate there was a prior.
Miss Player,
I'm sorry.
dial it back a little bit, ma'am. Yeah, it was dismissed. Okay. What's the point?
It was dismissed because it was filed in error. So the point is, you guys
Okay.
had an understanding that I didn't owe 10,000, and that the credit that you guys were going to apply, you had a credit to apply, and if I owed $10,175, then we know that the
Is
credit.
this a question for the
Okay, so
witness?
I thought
so
you asked what the
King,
point.
Miss King,
Yes.
okay, so at the time of the last dismissal, did they
Yes.
still owe money?
Yes.
Okay, do you know how much money they owed at the time of the last dismissal?
It says 5/11. I can only attest to what I can see closest to that date, which is on 5/6. And that was $14,639.45.
Okay.
Like Ms. said, since it was filed earlier than that, it's probably where the $10,000 came from.
Okay, so at the date that it was dismissed, there was still money owed.
Yes. A dismissal doesn't mean that we wiped the balance. It just means that it was an error internally. We just dismissed it for that.
Okay. All right, go ahead, Ms. Player.
Okay, so then I'll also ask you again, on or around, give me 1 second. And can you also give me the last date while I'm looking at this? Can you give me the last date based off of your emails of the email conversation we had concerning the credit? What was the
Last date?
wait a minute, I may have it. May 11th. So yeah, on the last date, May 11th, one of your emails had May 11th from Melissa Hayes.
Mhm.
That was the same day that it was filed, it looks like, at the court, where there was based off of your evidence and mine, to please accept the sincerest apology for the time frame taken to determine your credit request. Do you see that?
I'll pull that back up. Give me 1 second.
Okay.
You said it was with Alyssa?
Alyssa Hayes.
Okay.
And it was in the evening. Well, it said good evening, but it's 12:40. Oh, well, it was 12:48 a.m. in the morning, actually. Wow, didn't even really realize that.
1 sec while I pull it up. I'm not seeing that specific email, but let me just keep looking through.
Okay. Well, we'll move on. I have submitted it in evidence. It should be somewhere on the
I see it now. I see it on May 11th. Yes, I do see that.
Okay. So then also, after that, I received a notice in the mail for a renewal of my lease. Also, it will be an increase. Are you aware of the letter that was sent to me to actually renew the lease? Because at this time, we're looking at, let me see the date of the letter you sent for the lease renewal, because we're going to see how much I owe.
Okay. Let me pull it up in your attachments.
1 second, I got so much. Just give me 1 second and I'll give you the lease. Okay, this is 6/20/2023. Did you not send me on June 20th, 2023, a notice of rent increase and from First Key concerning my lease to renew it on June 20th, 2023?
June 20th?
Yeah, June 20th, 2023.
Let me see. Might be in the memos. We have a renewals team that reaches out, so it probably wasn't one of the PMs, probably was renewals. But
Okay.
I will look at the memos because they leave notes.
Well, I can make sure that I scan this in so that you can have a copy of this invitation to renew my lease. Can we look at the ledger real quick?
Ma'am,
Yeah.
what's the
Yes.
point of the lease renewal?
The point of the lease renewal is that even at June 20, 2023, I want to see the ledger and the amount that was owed at that time, since she brought up the ledger, because they offered to renew my lease with that amount still, quote unquote, outstanding. They were full aware that I didn't have an amount outstanding and that they were supposed to compensate and clear my debt. So this is also evidence that they even offered me to stay after, let's see, 6/20. It says I owe $49,000. Is that 6/20?
That was 2024.
Oh, 2020. Okay.
Yeah.
So 6/20, it looks like I owe 17,224. Is that right?
Yes, that's what I'm seeing.
So then at that time, I was offered to renew my lease at that time. Also, they filed again now at bringing it current. So we're looking at September at this time for 18,000.
Okay, Ms. Player, can I ask you a couple of questions? So I'm looking at the ledger.
Hold on
So
one second.
is it your contention that
Oh,
the issues with the apartment made it such that they would wipe your total debt clean?
well, that is what the consensus was, and even and see, the question really wasn't about the amount of the rent owed. Even with the last attorney, they were clearing the debt. The problem was they wanted me to move after they had already said that I could stay there. So I said, "Well, you're
Okay,
clearing the debt,
wait. Let me ask you, do you have something in writing that where they said the amount of the debt that they meant to clear? Like they're gonna give you a credit for $17,000, or they're gonna go ahead and wipe 17,000 or credit you 17.
Well,
Do you have no, well, listen to my question carefully.
yes, ma'am.
So first let me explain why I'm asking you this, because I don't want you to think I'm beating up on you, but a lot of people who are not from Georgia come from other jurisdictions, and the law is very different in other jurisdictions. In Georgia, as long as you are in the property and in possession of the property, you owe the rent and fees that are due that come with possession of the property. Now, if you have an issue where it's a repair issue or a remediation issue, and you've given notice to the property owner, the landlord, and they have failed to ameliorate the problem, if they haven't fixed whatever it was supposed to be, then you have the opportunity to pay for those things to be fixed, and that would be a credit offset against your rental amount that is owed. If they choose to give you a credit, that's fine. They're not required to do that. But if they do so, it should be in writing somewhere that they've given you a credit equal to a certain amount of money. Now, do you have something in writing that says they gave you a credit, not what you all discussed, not what should have been agreed, but something in writing that says they were going to credit you a certain amount of money?
The only thing I have is that they were going to give a credit, not the dollar amount. But I will say in court,
So, because
when we
here
were
it
at
shows
court,
that
he
they
said it. Does
they
that make a
credited,
difference?
well, here it says they credited 1 month's rent. But if you're arguing that they should have wiped your debt clean,
That
I'm
is
gonna
what they
tell
in
you,
court.
I've been doing this since magistrate court since 2012. I've never seen a landlord say they were gonna wipe a debt clean.
They said it in court. The last court hearing that we had, he said it in
Mhm.
court that they were willing to wipe that because they really didn't want to be countersued for
Okay,
the amount that
if
they could be. They said it in court that they
if
was going
you
to
were,
wipe the entire debt
did they
clean.
say if they wipe the debt clean, you have to leave?
They want to, yeah, they do want me to leave.
Okay, so that I understand. So what they're saying is they want possession of their property. They want you
Right,
out.
right.
They don't, at this point, they don't think they're going to get their money. And I'm speaking for Mr. Bolden, but Mr. Bolden can correct me when it's his time to speak. But I've seen this before. I've not seen what you're saying, that they wiped your debt and then you get to stay. That never happens.
Well,
No,
that,
no, no. Listen to Miss Player.
yes,
They
ma'am.
want their property back
I
because
get
they
it.
want somebody who's going to pay the rent.
I
You've
get
been
that.
living rent free since 12 since December 1st of 2022, which means they've lost a whole year, almost a whole year of rental income. So if you will agree to leave, they'll say, okay, we're not even going to pursue the potential judgment that we could get from you. We just want our property back. But you want to have your cake and eat it too, which is, I want to live free and stay.
Ma'am, that's not what I want. What I want is justice. What I want is they harmed my daughter. My daughter had to drop out of school. I have submitted medical bills, which they have the medical bills. They were fully aware of my daughter's illness. It
But
was not a
ma'am,
question of if they
Miss
if it was
Player,
black mold
Miss
or
Player,
if
Miss
my
Player,
daughter's sick.
Miss Player,
Yes,
everybody
ma'am.
in a civil suit who alleges damages has a responsibility to ameliorate those damages and mitigate those damages to the best that they can. So I'm gonna tell you, in a civil suit where your counterclaim is for damages done to your daughter because of a mold infestation, you have the responsibility of lessening those damages, and but you chose to stay and you had to pay. Listen to me. You hadn't paid rent, which means that the rent you should have been paying, you could have been accruing and moved to another place. But instead of doing that, you stayed, didn't pay rent. Your daughter was in an unhealthy situation. You didn't mitigate the damages in any way. And now you want to stay in a place where you claim it's unsafe. You want to stay there for free, and then you want to sue for damages that you didn't lessen when you could have had the money that you didn't pay for rent in order to move to a different place. You could still
Ma'am, I
sue.
could not move. I could not move because everywhere that I tried to move to would not move because it looked like I owed these people $18,000 when they said that they would give me the credit. It clearly says in writing that they will give me the credit. You see that I was quote
Ma'am, I
unquote
didn't,
owed $10,000 and they dismissed it for filed in error. They know that I didn't owe them the 10,000 because they
I
had agreed
saw
upon
a credit, but I didn't see anything that you've produced that said that they were going to wipe your debt clean. There's nothing in writing, ma'am.
it. And it doesn't matter that it was said in magistrate court either.
The magistrate court is, I mean, they record cases. I don't know if they've recorded it, but the judge there should have recorded that somewhere on the documents that you were getting a credit. But if that happened in magistrate court, why are y'all here? Like, why is
because
the
I
case
had
here?
because I had a countersuit on the matter. I had a countersuit on the matter. So because the countersuit was more
So
than
they were gonna,
$15,000, we
they were
had to
gonna,
move.
what's the countersuit for?
The countersuit was more than $15,000, so we had to move from magistrate to state according to that judge.
So they had agreed
And
to
so
wipe
we've
your
been
debt.
waiting to get on your calendar for
Okay,
6
but
weeks, and I
Ms.
couldn't
Player,
move.
I'm just trying to tell you what it looks like and what the law says. So you gave up the opportunity to have the debt wiped to just move out of the property because you think you'll get more by suing for the counterclaim. But
But
what I've
that's not true.
explained to you is with the counterclaim, you have a duty to lessen the damages. And if you stayed in a place where your daughter was suffering, even though you didn't pay rent for a whole year, so you should have had $2,035 times however many months to move, I would you stay in a place even if you had difficulty moving? Why would you stay in a place? Because you can rent a house from a person, a property owner, an individual landlord, if you walk up to them with cash. Now, this I know personally. Cash in hand gets you save money by not paying from the time you stop paying through today. Sue for something that you had a responsibility to lessen your damages. That's in the
Well,
law.
well,
You're
ma'am,
trying to stay in a property where they've already said, just leave because we'll wipe away whatever's there. But now you're saying that because they said that, you want them to wipe it away and you
mhm.
stay. And that's just not going to happen.
I'm feeling like I'm not able to explain myself, and I haven't even begun to speak on my countersuit. And I feel like it seems to me that you kind of see something and you got an image in your head based off of previous court hearings or court cases, and that's not the case in this
No, I'm just
situation.
explaining
And
to you what the law
I'm telling
is,
you that
ma'am.
well, I'm telling you that I was not trying to sit there and live rent free. I wanted to leave from the property and was unable to leave. I can submit to you in your office places where I was denied, where I've never been denied a place to live based off of the fact that it looked like I owed these people. They know that I didn't owe them that amount of money. That's why they filed it in error. And you see the apology letter at 12:48 a.m. on May 11th, the same day that it was filed in your office at 12:48 a.m. They're apologizing because they knew that I did not owe them that money. I'm not sitting here just trying to live somewhere rent free. We went to court and it took this long to get on the calendar But what I could not move, they put me in a position where I could not move. And the house is not still secure because it's still raining in the house. It's still mold and everything else in the house. I am stuck in an environment where I can't go anywhere. And so
Okay, let me ask you this. So I understand that they did some things. On here, it says that there was work orders and some work was done. But you're saying that there's water still coming into the apartment.
it's not an apartment, it's a house. And yes, from the upstairs, they
Okay,
came again. They did come again for upstairs because once I
okay,
moved my daughter from downstairs, we moved all her stuff from the downstairs area because it's downstairs area. We moved her all the way up to the north, this side of the house. And then
okay,
probably I don't even know, weeks after that, the water started coming through there in the carpet. So they came and they did find mold again in the house, and they cut out the ceiling, cut out the carpet. All this time I'm trying to move. Not only this, I take care of my mother who is bedridden in the hospital, has a nurse 8 hours a day in that house, physical therapist, occupational therapist, who's in the front area of my house. I I take care of. She couldn't scratch her nose if she needed to. Like I do everything for my mother. So when that being said, I did not want to be in this environment. I felt stuck in this environment. And so I could do nothing but wait. And I was
okay.
the
One
one
more question.
calling and actively coming to the court.
I got
I'm
you.
not sitting, I'm actively coming, like trying to get the court date, trying to figure out what we, because I'm trying to get out of this place. I'm not just trying to stay in this place.
Okay, question. Since you said it's a house and they haven't been able to fix the problem, did you call in a company, not them, but did you find a company or call in a company to come in to assess the problem or to give you an estimate of what it would take to fix the problem if
Uh,
you paid for it?
the last person that came that fixed the wall and they said it's in the house, it's internal, it's in the pipes, it's in the structure. There's nothing we can do about that house. Even if they would probably have to tear the house down or do something because it's internal. So it's going to go
Did
from
they
one
give
place to
you
the other.
did they give you something in writing that said that?
No, but I mean, if I would have knew that I need to get that in writing, like I mean, I guess we could call the people back, but that's what they said concerning. They said it didn't matter because even with them fixing this and pulling up the carpet again and tearing out the walls again, that it was going to continue from place to place in the house. There was just nothing I can do about it. My mom is literally right underneath my door. So I care about the well-being of my family and especially my elderly mother who is literally hospital bedbound. So I'm not
Okay.
just kicking it in this house. Like, what do they call those people? I'm not
What
one of those
no, I'm
people.
not. What was the name of the company that you called to do that assessment?
Whoever the first piece sent out there.
No, no. So you're not hearing me. When First Key fails you and they fail to fix the problem, then you have the right to call somebody in yourself, separate from what they're doing, and ask them to assess the problem and pay them yourself. And then under Georgia law, that would work as an offset against anything that you would owe First Key. So say
Well,
First Key said, hold on. First Key says you owe $40,000 and you call in a company and that company says, well, it'll take us, if we can get this fixed for about $18,000. You get like a list of things that need to be done and you pay them to fix that. Because you're not paying the rent, you know that money's accruing, but if First Key then comes to court and says, well, you owe $40,000, you have a company that says $18,000, we fixed the problem, here it is, here's the bill that I paid. Then you give it to First Key, that sets an offset against what you would owe. So that would be your credit. Like if they don't choose to give you a credit, you can have the property fixed and then that becomes the credit against what you would owe them. Were you ever able to call in anyone to
I
do
did.
that?
I didn't know to do that. I went off of the word of the guy who came to fix it. He said, because when it happened downstairs and they
Mm-hmm,
did all the stuff and I moved my daughter upstairs, months after
mm-hmm.
that, it happened upstairs. And so when they came and we said, okay, for this is going from room to room, he said it was internal, it was in the pipes, it was in the walls. It didn't matter that wherever it's in it's in the walls of the house. It's nothing that they could do about it. Like they can fix it temporarily, but it's going to happen somewhere else. And what you did, because then it went downstairs in the front area when you first walk into the house. And then now it's in my kitchen above my kitchen sink. So it's been just bouncing around. And once again, I'm stuck in this matter. It's not like, I mean, I can't move because it looks like I owe these people. No one wants to rent to me because it looks like I owe them all this money. They said they would give me the credit. They knew, and they were giving me the credit based off of my daughter's sickness and illness and those things, not based off of the inconvenience of having the mold in the house or having the walls wide open for months at a time. Like, that's not why they were giving me the credit. They were giving me the credit based off of my daughter. And we see that they acknowledged that they were going to give me a credit. They said they were going. We know that they dismissed it for 10,000. They turned around and said in court that they would just go ahead and get rid of the 18,000. And I'm like, well, I can't move in 7 days with my mom. I have a whole medical team that I have to move. I have to get in contact with Coweta County to do all of that stuff. And plus, who said 18,000? My daughter. Look what you did with my daughter. Does that not have any bearing?
So the 18,000, the
Yeah.
18,000 credit you said would not have been enough, which is why you held on for this court date. What is it you claim that for your counterclaim? What is it that you claim that you're entitled to?
I wanted at that time the amount cleared, which would have been the 18,000, but I would have needed at least 60 because that was the amount that was owed. I said, even in my answer, go ahead and clear the amount owed and give me 30 days to get my mother into another location, because with me having my mother having legal guardianship over her, I have to let Coweta County know before I move somewhere. She has a whole medical team with physical therapists and occupational therapists that come in. I have a nurse 8 hours a day. I would need at least 30 days and to be able to clear the debt, and I need at least 30 days to be able to get my mom's medical team and everything else Coweta notified. And I don't mind moving because I didn't have a problem. I didn't want to live there. But he said, oh, no, you got to be gone in 7 days. I said, I can't move my mom in 7 days. Well, then forget it. And so then the judge sent it over to state court because the countersuit was higher than 15,000.
Yeah, because judges can't, like, the most we can give is 7 days. If you all can't work something out beyond 7 days, that's the maximum allowed by law that a judge can order in an eviction. So I understand that you have issues that, your mom's healthcare is a little bit more complicated, but even if they say no 7 days, then we're bound by that because that's what the law says. We can't give you more time. Y'all can agree to more time, but we can't give you more time. And so if they're unwilling to agree to it, then that's how you ended up here.
I could have been gone in September or October, whatever, 30 days after the fact. I could have been gone 30 days. All I needed was time. I have to let the courts know anytime that I move with my mom because I have legal guardianship of her. And so I have to let them know. I have to be able to move the medical team. I have to be able to do all of those things. Wipe the debt clean. We'll call it even Steven. I don't even have to renew the lease, even though you guys even offered me to renew the lease, and I'm owing all this money. That's because they really knew I didn't owe all this money. What they agreed to. However, I would have been good, Your Honor. I would have been good with just giving me enough time to get my mother into a stable place and them wiping the debt. And we wouldn't even be here. I could move somewhere else, but I can't apply for somewhere. And I've never had an apartment. You can look. I don't have issues like this, but because it looks like I owe them all this money, no one wants to rent to us. And I have my whole mother.
Okay. So the next thing is, how much are you claiming as part? So the 18,000 in the 30 days, not too much I can do about that because that happened in magistrate court. And since that wasn't solidified down there, then now your case comes up here for what is called a de novo review. So I'm looking at it with fresh eyes. So that's off the table. So what is the counterclaim?
The counterclaim is for $150,000, and that's for my daughter's illness. That
Okay.
I've submitted the documentation from the doctors, the emergency room care. She's now on nebulizers. She has to have an asthma pump all the time. It was really for the inconvenience.
Okay. Do you have medical bills that show actual costs, not just pain and suffering, inconvenience, but what are your actual costs?
Well, I do have insurance because I didn't want those bills to accrue and make my credit go down.
That doesn't matter. Do you have actual costs that were billed to you for your daughter's care?
Yes, Yes, I do.
Okay, what was the actual cost of your daughter's care?
Um, I would need to calculate it all, or do you want me to just give you every bill total on each one of these bills?
Like categories. So for the doctors, how much did you pay? For medicines, how much did you pay? For anything having to do with her illness?
So, 10,000.
Your Honor, can I say that the reason behind the mode and everything else, I mean, the whole reason why we're here from the beginning is because that first key did shabby work from the beginning.
Okay, I get that, Mr. Player, but here's the thing. Essentially you have two options. You can stay and pay, or you can leave. And so y'all have stayed long enough through all of these issues to accrue an amount owing on the rent that is huge. Had you like start looking for a place when the issues first started, or when you first knew that they weren't fixing the issues, like they've come out several times, we're not able to fix them, we need to start looking for some place to go. I get that you have your mother has medical issues and everything, but you could have given yourself time at that point to kind of find some place without accruing a huge amount of money. What I'm saying is, I get what you're saying, and I'm not saying that you're wrong. What I'm saying is, under Georgia law, this is the way it works. If you're in the property, you have to pay. If you have an issue that causes you to not be able to use your home, then that's different. Like if you had moved and said that you were what we call constructively evicted because the home was not livable, that's a whole different thing. You could probably have gotten some relief under that because you moved because you were forced out. That's a different thing. But you never moved and you kept accruing. And I get that, but listen to me carefully. The law is not the law's pretty hard and fast. Like if you live in the place, you're owing the money. If there's a problem and they don't fix it, you can fix it yourself and get a credit against what you owe, or you can leave. I get that you want all this white because you don't want it on your what you don't want it on your record, but the where you failed was you stopped paying your rent. Even if they had given you a credit, you would have gotten that back. So if you had negotiated successfully the credit that you asked for, that would have come back to you. But you can't stay in the property and not pay your rent. When you stop paying the rent, that's when you began to accrue an amount that was owed that was probably more than you can pay out of pocket right now.
So is this not, I mean, even with them stringing me along week by week, month by month, oh, okay, we're
Because
coming with the credit. Okay, they're looking
But
at the
think
credit.
about it
Okay.
though. You still are paying to live in the place. If they had given you a credit, you would have that money back. So
Well,
they
even in
credited.
our initial conversation, I mean, I just knew that because we went in person and met with these people and their legal team in person.
And
We
did they
knew then that it was more than a month to month thing. I
did
feel
they
like they did this $2,000 thing. Look at the date they posted that $2,000 credit. It was right before we went to court. Right before we went to court, they posted that just to say, oh, okay, let's put something on there because they knew what they had agreed to with me.
I get that, but if somebody agrees to something in like verbally, but you come into court and you know they're going to have documents and you have documents and they don't tell you that same thing in writing, then when they come to court, what I'm looking at in the documents that I'm looking at says that you got a credit. You
Right, right.
got me? It also says that you stop paying your rent. If you Even if you pay your rent and you get a credit, well, you're even then. You're living there, they've paid you back for paying your rent. In this case, you stop paying and you want a credit.
Well,
And
not
you're still
essentially. What I
representing
want
a
the credit
profit.
to the account, but I countersued. The only reason I countersued was because of the amount that they were saying that I owed. Originally, I wasn't going to countersue them. Originally, I will be honest. Originally, once they got everything fixed and they said they were going to wipe the debt clean, 30 days I'm out of the house, I wasn't going to countersue them. But then when they're like, oh, well, you have to go. No, we're not going to. I said, well, I have to get my mom out. I have to do this. Well, no. I said, but you asked me, y'all sent me a lease to renew my lease. Now you're taking back and rescinding the lease. And so it's like they turned on me when I had been nothing but doing the right thing the entire time, trusting each one of these emails. I got over 15 emails where they're stringing me along week by week of applying this thing. And then right before we go to court, they put a credit on there, which I never even knew about this $2,000 credit, or I would have brought this up when we spoke, when we went to court. It looks like they put this on right before we went to magistrate court. Then when we get to magistrate court, okay, we're going to clear the debt. That's what the original plan. You're not doing me a favor. That was the original plan. So it's like, now you're going to get rid of the debt, but now you want me to go. And I was a good tenant all these other years that I've been there. And so now you want me to go. Okay, well then I need at least 30 days so I can get my mom out. No, you got to be gone within 7 days. Well, that's not going to work for me. Well, let's go. And so there we go. So I said, well, I'll countersue for what you really owe me. What you really owe me is damages to my daughter, her health, her breathing. Now she's on a nebulizer and albuterol forever, or however long it's going to last. I don't want to speak that over my child, but however long that's going to last, she's on an albuterol and nebulizer even to this day because of that. And I have the documents for that. So then let's just go ahead and see what it do then, because you hurt my daughter. And so if you're not going to be fair to me, then let me just go ahead and sue for what you owe me.
Okay, well, that's what I'm asking is you have the documents to show what you've paid or what you've been billed for your daughter's care.
I do.
Okay, that's what
for me to calculate, it's roughly like $12,000. But for me to, I would have to sit here and calculate.
But that's
I'm sorry.
You came to court based on your counterclaim.
Yes.
So you got to be prepared, because this is the time when you have to prove your counterclaim. What you're saying to me is, I got a court date. It's taken a long time, so you had plenty of time to prepare. But once I'm here at the court date, I don't have my records together, and I can say it's about. But what I'm asking you for is like actual numbers. Like, what did you pay for her health care? What did you pay the doctors? What did you pay to the emergency room? What did you been? And I'm not asking what was covered by insurance. I'm asking what was billed to you, whether insurance covered it or not. What were the actual numbers billed? What doctors did she see? What that's how you make a claim, ma'am.
Well, yeah, I submitted all of that stuff in my claim, but to go in and look at the actual numbers, I mean,
that's the only way I can make a decision is they've given me actual numbers. They've given me the ledger that shows what payments were made or not made. They've given me what they claim is the credit that they gave you. But you're countersuing. Your countersuit is related to this, but I can't use the same numbers because your countersuit is based on numbers that you say were occasioned by the mold in the home and so if those numbers I gotta have in order for you to make your claim.
Well, not just the numbers of what I spent for medical, but for pain and suffering and all of that as well.
We're not even there yet, ma'am. First, we start with actual damages before we get to pain and suffering. If you have no actual damages, then you can't get pain and suffering.
Yes, I do have actual damages. One is for $2,279.05.
Okay, and where was that to?
That was to Piedmont Laboratory, Radiology, and Emergency Services.
When was that? When did that happen?
This particular one is 1/26/23.
And whose name is on it as the patient?
Paris Player, my daughter.
Paris? Okay.
Yeah, Paris Player.
All right. Do you have another bill?
Yeah. $209.05.
Okay. And who was that to?
Piedmont Urgent Care.
Okay. And what was that for?
Date 1/30/23. Office visit.
Okay. Did she receive any treatment that came with that office visit?
Yes, the treatment is in, I've submitted it to your office, all the treatments. I had to bill separately.
So when you have a claim or a counterclaim, you can submit them to my office, but they have to be on the record. So both sides have the opportunity to hear it and to, if the other side wishes to dispute anything. So even if you send them to my office, you still have to prove your claim on the record.
Okay, yes, ma'am. This one is these are from 2022. Looks like the very first time was March. Looks like 8/25/21. 1/11/23 wasn't right. That was the date it was received. That's not the date that the service was.
What was the date of service?
8/5/21.
Okay, and what was that for?
Oh, wait, shoot.
Your Honor, I'm going to object to the extent, not only to hearsay, but I think even more importantly, there was a renewal lease, I believe, between the parties. And
Okay, so I
okay, her
have
counterclaim, Mr. Bolden, I'm trying to understand your objection because her counterclaim is not.
She renewed the lease September
Okay.
the 8th, 2022. So anything prior to that, I think certainly needs to be excluded.
Okay.
Notwithstanding the
well,
general objections to not having seen any of this, but I understand.
can I say anything or no?
Well, okay, first of all, let me ask two questions. One, when you say you sent it to my office, does that mean you filed it electronically with the clerk of court?
Yes, ma'am.
Okay, so Mr. Bolden should have access to that.
Yes, ma'am.
All right,
And
number one.
hold
on. Number two, Mr. Bolden has made a point, a motion for having anything after September 8th, 2022 excluded. Reason being, that was the time when you renewed the lease, and that would have been your obligation to mitigate any damages that were accruing. So if you knew that your daughter was suffering from the issues in the house prior to that and you still renewed the lease, that means that anything prior to that you're in acceptance of because you decided to stay.
Your Honor,
No, ma'am. Hold on, Ricky.
Hold on.
Hold on, Ricky.
I can't talk to both of y'all at the same time.
We did not discover my daughter. She does have medical bills prior to that because we didn't even discover the black mold poisoning in the wall until December of 2022 after the lease was signed is when First discovered the black mold in the wall. So as she was getting sick through the year and missing school at Kennesaw State, failing because she's sick, coming back and forth, this was before we knew. But when they actually broke out the wall and looked, then we knew that that's what it, because when she went upstairs, it went away. So we knew, so the stuff from before, she was sick before.
Okay.
Is that what you were going to say, Ricky?
Yeah, we had no idea that there was black mold in the house at that time.
Okay,
But
when did you all kind of discover that there was an issue that you needed to alert the First Key about?
December.
Okay, December of 2022.
Yes.
Okay. All right. All right. So to the extent that your objection is to any damages accrued after the renewed lease, the court will overrule the objection to the extent that anything from December 2022 forward will be at least considered by the court with respect to the damages. All right, go ahead, ma'am.
Okay, urgent care charges, $533.10.
When was that?
Date of visit for this one is January 13th, 2022.
Okay, that
And
one's not gonna count.
January of that year?
That was before you renewed, and that
No,
was before you knew that there was mold.
that was before I knew it was mold.
Right.
We didn't discover it was mold in the room until December. And the only reason we discovered it is because we walked in there and it was just, we walked into, what was it, water in the floor and in the carpet or something we were doing in the carpet?
Miss Player, let me ask you this. So y'all moved in initially, in August of 2020?
Yes, ma'am.
So, and you lived there through that first, lease period,
Yes.
and then you renewed for the second lease period, and
Yes,
none
ma'am.
of this happened during the first lease period.
There was a little bit of dripping, and I think they came out and fixed it, which was in the kitchen over the kitchen table. But we just thought it was like, we thought the roof was leaking and maybe it was something that had to do with the roof. But they
But
fixed
also,
Hold on, sir. Hold
okay.
on. Okay. All right. Did you have any other bills?
yeah. Um, here's what date is this? 21. Uh, says applied to date. Well, I don't think that would help. Paris player applied to date would be $2,259.81.
What was that figure and
What was that again? $2,259.81. That
And
was for what
81.
now?
That it doesn't say, it says applied to date.
No, that sounds like a credit, maybe from a insurance. That doesn't sound like a bill.
Okay. Okay. I just printed out everything from the benefit site from everything we spent. So
Okay, do you have any medical costs? I mean, any prescription costs like nebulizer or asthma pump or anything?
um I mean I always have copays. So
Okay. So it's just what I mean, Miss Player, is pain and suffering under the law doesn't come unless you have actual damages. And you got to prove the actual damages before the court can even get to the point of considering anything related to pain and suffering. So that's why I'm taking you through this, because you got to show that you had actual damages that were caused by the mold or anything.
I have actual damages as I can pull in from the Kennesaw State University where she was missing so many days because she was sick. So she ended up leaving that semester. She failed like almost everything and she was a straight A student on a scholarship. And it was all her excuses to her teacher were her being sick. So her whole first semester went out the window. I paid $36,000 for her to go to Kennesaw State University. So and she did have a scholarship for the Atlanta scholarship. But I mean, that's considered a damage to me. It's considered a damage to me that she still has to be on these asthma and nebulizers. Isn't that considered damage?
If it were caused by the home, that could be, yes, ma'am. Okay. Did you have anything else at this time?
No.
All right. Mr. Bolden, did you have any questions for Ms. Player?
No, I just want to verify that you don't have any qualification or expertise in mold, do you, ma'am, or licensing or
In mold?
mm-hmm.
No.
AMG?
But the people who first key acquired did.
Right.
They were mold
Right.
specialists.
And
They were mold specialists.
you don't have anything here that you don't have an expert or any kind of medical personnel to connect any causation of that organic growth in that house during the time period your daughter was there to your daughter's health?
Well, other than the doctors, no, I don't.
You don't have anybody here to testify to that. Okay.
No,
No.
other than your ledger that even acknowledges that there were black mold poisoning. They were aware because your experts that you sent to the house indicated that that's what it is. That's why it's documented in writing.
This is your claim, and so I just want to make sure
Yeah, but your evidence supported that.
you know, I want to make sure that just crossing T's and dotting I's is all. Okay, thank you, ma'am.
Yes, sir. Your evidence supported that. So
Okay. All right. So, the total, did you have anything else at this time, Mr. Bolden?
No, ma'am.
Ms. Player?
no, I can't think of anything else.
All right. So, Ms. Blair, I hate when people go away feeling like they've been ill-treated by the justice system. So I try and explain things as I go. And I've been doing evictions a long time. I was in magistrate court for 4 years, and I've been in this job for 8. So when I say I pretty much know what I'm talking about when it comes to Georgia law on evictions, I'm pretty good at it. So the issue is people assume that they can just stop paying rent. And that because they stop paying rent, they're going to get all of these, I guess, benefits or bonuses from, because things aren't working from the side of the landlord. So we'll just stop paying our rent. There's almost no scenario under Georgia law where you can just stop paying rent if you're in possession of the property. So the way it works is if you're in possession of the property, you owe the rent and fees and all of those things. And like I said, if they fail to fix whatever should be fixed to make the home livable or to fix any problems, then you can do it yourself and charge them, which would be an offset against your rent. Or you can bring in your own company, pay them, and that would be an offset against your rent. So I don't know of any other situation where you can just not pay. The other option would be that if you felt like the house was so unlivable that you were forced to move out, then that would be what's called constructive eviction, and you could sue because of the constructive eviction, meaning that the house was so bad, I had to move, and because I had to move, all of the things that flow from that, we can talk about in court, and possibly there would be either an offset or, a credit to or an offset for all of the rent or even damages because you forced me to move. Okay. But in this case, you stop paying the rent, you don't have anything in writing that says that they were going to clear the debt. But what I understand is at the magistrate court hearing, they were willing to clear the debt in order for you to vacate the premises. The sticking point at that point was you needed more than 7 days to vacate the premises, and they weren't willing to give you the 7 days. So you all were at an impasse, and then the case came to me with your attendant counterclaim. Now, like I said, the amount owed is the amount owed. So through November 1st, that amount would be $64,696. Mr. Bolden didn't want to admit, but AMG, when you talk about something organic caused by water, I mean, come on, that's mold. I don't know if it's black poisonous mold because I don't have anything from either side that says that. But mold in any form can cause respiratory issues, even if it's not black poisonous mold. Mold growth in a home can cause respiratory issues and those type of things. And so you have you stated on the record that you have some bills that were accrued because your daughter had to go to urgent care, that she had to start using a nebulizer, that she may have had some respiratory issues, but the maximum amount of those seems to be about a little bit like in the $3,000 range. But I hate to keep emphasizing this part, and I know you say that it was because the credit wasn't applied that you couldn't go anywhere else because it seemed that you had the $18,000 that you still owed.
Exactly.
The
I have
issue,
documentation of them denying me.
the issue is you did owe it. And so it was your choice to stop paying the rent. Under no legal, there's no case law, there's no statute that said that as long as you're in the house, you don't have to pay rent. You're required to pay the rent. And so anything that prevented you from moving because you owed the money, it's because you didn't pay the rent. And because you had months and months and months where you didn't pay, you could have, like, you should have been saving that money and you could have paid them off and moved or paid for another house. That all of those are all because you stopped paying the rent. And I hate it for you because a lot of people think that that's the fix for whatever the problem is. I'm going to just stop paying the rent. That's the worst thing that you can do.
Mercy.
Because if you had moved, like if you had been paying the rent and you moved and you sued them still for this, you could have gone to another place, still had your credit intact, and still, if you wanted to pursue claims against them, you could have pursued them under a civil claim, not an eviction. But
so it
as long
doesn't
as
even matter that they had filed for $10,000 and then voluntarily dismissed it, saying that they filed in an
Ma'am,
error. Does
ma'am,
that not show?
people dismiss evictions all the time. We've had people dismiss evictions because they can't take. So if they file an eviction and somebody pays something, they can't take the money. If they take the money, then the eviction is invalidated. They may have filed it for the wrong amount. If they do that, then they dismiss the claim. If they decide they just don't want to pursue the eviction because they know that things are behind and they're not going to get a hearing anytime soon, that people dismiss evictions for all those reasons and more. So I can't.
The apology letter at 12:48 in the morning, Judge. The apology letter from First Key's manager at 12:48 in the morning. That don't mean nothing either.
But ma'am,
with the $10,000
okay,
saying that I owe.
okay, let me ask you this. So at that point, when they said that we're gonna move this eviction and your assumption was I no longer owe this $10,000. What about the rest of the $54,000 that has accrued since then? You just thought that you'd go and live there with and not have to pay rent?
Once we went to, no, that's not what I thought. Once we went to the court and they dismissed at 10,000. Then we got there and they were dismissing at 18,000. We went back and forth. I didn't know that we was going to take this long to have to go back to court.
They didn't
go before
dismiss.
state court.
You all couldn't reach it.
I wasn't even under contract. I'm not under contract with them.
Does
I'm
not
not even
matter.
under contract with them. So
Does not
you're telling me about a year, like I don't even have a lease. I don't know the amount to pay. And not only that, Your Honor, I
Okay.
didn't even get to tell you. I never even told you. I don't even have access to pay the rent. I don't have access to pay the rent. I don't have access to pay any of that stuff. I can't get in on any online portal or do any of that stuff as of now. I'm not even under lease. I'm not even under lease agreement with them. That
So
lease ended.
I feel
And
like
then,
I'm
how
teaching
was I supposed to
dispossessory
even?
because I taught it at New Judge School. So I'm going to teach it to you, Ms.
Yes,
Claire,
ma'am.
and
Teach it
to
to
everybody
me.
else who's listening. So please, ladies and gentlemen, if you are listening, if you would ever want to lease an apartment or anything in the future, listen to me. Under Georgia law, if you are in possession of the property, you have to pay the rent. If there's an issue of maintenance, you have to give notice. If after giving notice that issue is not repaired, you have the right to repair it yourself and charge for that, which would be an offset against your rent. You also have the right to pay somebody to do it, which would be an offset against your rent. And you always have the right to move. And it's an issue of I'm breaking my lease, then you can tell them there's a maintenance issue and this is why I'm being forced out of the home because there's no longer a place where I can safely live. Okay, so with all of that being said, if you are past the point of your lease and you're still in the home, you become a tenant. You are still a tenant, but you do not have a lease. So you travel under the lease terms that you signed under, which would mean that you would owe the same amount of rent, you would owe the same late fees, you would owe the same utilities, and until you moved out. The landlord at that point, if you did not have a lease, would have to give you 60 days notice for you to be to leave the property. So they would have to give you 60 days notice saying, hey, we want you out of the property. You, on the other hand, would have to give them 30 days notice saying we are leaving the property. Either of you, either side can break the agreement that you have, even though you don't have a lease in writing, you have a tenancy at will, I believe it's called. And so at that point, they can give you 60 days to leave and you have to leave, or you can give them 30 days saying I'm leaving, and there's no recourse for them as long as you've not damaged the property. Okay, so
So
ma'am.
does that mean the amount that they say that I owe is not the right amount if they did it based off of the terms that weren't from the original terms that I originally signed, and it's based off of some new term of 2,500 when my original term was 2,000?
Okay, the amount that he has pled for is $2,035 a month. So they did not go up on your rent. That's what he stated at the beginning, and that's what the ledger said. I looked through the ledger. Every time there was an amount for rent that was charged, it was $2,035. So number one. Number two, so you are under a lease, even though you haven't signed one, as long as you agree to stay in the property and as long as they keep accepting the money. So you could have paid the same way. If you got to a point where they weren't accepting your money, you could have sent it to them to the address of the business office by certified mail as an attempt to pay. But once they file an eviction, they're not allowed to take the money, because if they take the money at that point, it invalidates the eviction and you go back to square one. So they can dismiss if they wish to, but if they file an eviction and they are intent on getting you out, then at that point, they cannot accept money. They can only come to court. Now, the other thing is, the reason that they agreed to wipe the slate the last time was because in magistrate courts, because they really just want possession. And I got landlords all day, every day. They don't fight about the money because most times they know they're not going to get it. But they do fight about possession of the property, because as long as you're in it, they're not making money from new tenants. And they know they're probably not going to get the money from you all, even if they sue you for it. So even if they get a judgment, they're not going to get it. So they'll say, we'll give up our judgment just to get property back. And like I said, unless you are on good terms with them where they're willing to give you more than 7 days, I can only give you 7 days. If they're not willing to give you 30 days to move your mom and all of that, you have to think about the fact that you've had almost a year since the lease renewed. You could have made those provisions in that period of time because you weren't paying the rent, ma'am. You could have bought a house in that period of time. $2,035 a month. That would have been a nice little down payment, and you could have bought a house. There's plenty of them out here that you could have bought.
I just feel like I was bamboozled all the way around.
No, ma'am.
And I'm sitting here looking like the people, squatters. Now you got me sitting here looking like a squatter or somebody that, and, you know.
I'm just explaining to you how it works, and you always had the opportunity to seek legal counsel. I've had to give it to you here, but you were fighting on what you thought your knowledge of what it should be. But you always have the opportunity to seek legal counsel to assist you in your claim and counterclaim. What I'm telling you is this is how the law works. And for a lot of people, especially people who come from New York and other places up north where it's more tenant friendly, that's not how Georgia is.
Well, no, I'm from Georgia, born and raised, Georgia Baptist. So I guess I don't have an excuse.
Just saying. So, and I stand firm. And I even pulled my book to make sure this is the book. See it? See how big this book is? This portion of it is on leases. Leased stuff. So I even pulled my book. Like I said, I taught this at New Judge School. So I'm pretty clear on what's going on. And so the issue is going to be, I'm going to issue an eviction. I can only give you 7 days. If Mr. Bolden's willing to give you more time, fine. but I hate to see people squander the time they have. We're fighting to fix something that the man told you wasn't going to be fixed. At that point, you should have been making plans to get out of the house.
If I could have, I would have. Like I said, I had several denial letters, and it's because it looks like I owe First Key. Even from back when they've been saying they've been giving me the credit, I got 9 different emails. Like, I
Gotcha.
can't go anywhere. You got me stuck here. Then what you want me to do? So,
But imagine the leaseholder, I mean, the owners of the property, you all have been there long enough for them to have $64,000 that they can't collect.
okay, but imagine my daughter who has to breathe on breathing machines and asthma pumps and who failed her first semester at Kennesaw State because of the negligence of the people that they acquired in that house. And for them to come and tell me they're going to give me a credit, I'm sitting there like a dummy waiting on this credit. I'm the one initiating all of this
But ma'am,
contact.
I'm just going to say one more thing. When you get a credit usually means that you've paid something and somebody credits you against what you paid. You didn't pay anything. So what credit were you looking for?
They were saying that they were going to credit me in advance. Like they were going to credit my account. I wasn't going to have to pay rent for at least the next 6 months based off of the stuff that I brought to the office with the legal team. They already went, they had went through it. They had agreed to it.
And
All
a
of the
legal
above.
team produced nothing in writing.
Of course, yeah, no. All I have is the writing them saying they're going to give me the credit. I'm sorry, the credit still hasn't hit the account for you.
How much
Here's
is
the renewal of the lease. They even
and
want to give me the lease.
nothing says what the credit is. No number.
My bad on that one. So
I once had a guy tell me that he was sleeping with the property manager, and she told him he didn't have to pay rent. I couldn't. That first of all, that's an illegal thing. But second of all, I was like, look, if you don't have anything in writing that you don't have to pay the rent, the lease still says you got to pay the rent. That's what I have to go by. Whatever that last lease term was, the fact that you're in the property, you got to pay the rent. That's it. Just know for next time, you got to pay the rent. So at this point, the court is going to give possession of the property back to First Key plaintiffs, finding in favor of plaintiffs the amount owed through November 1st. And the court can only give 7 days for the eviction. 7 days would include the November 1st date. Judgment will be for $64,696. Because there's an acknowledged claim of AMG in the home, the court will give a $4,000 offset. So it'll be $60,696 for the judgment. And then the writ of possession will be signed, and you have 7 days to vacate the property. Mr. Bolden, anything?
Judge, I would just ask that the order include something that would require her to pay that amount into the registry if she files an appeal.
Okay, so ma'am, if you file an appeal of the court's order, the money has to be paid into the registry prior to the appeal being filed. If it's not paid, then the appeal will be dismissed.
okay.
All right. Okay, Mr. Bolden, do you have an order if you want to present that to my staff attorney?
I'll present it. I'm about to be in another hearing, Your Honor, at 1:30
That's
in
fine.
Gwinnett here, but within 24 hours.
Yes, sir.
Okay.
All right.
The last thing I'd ask is how do I get a copy of that book?
You got to be a magistrate to get that. Shoot, I had to hold on to that. They wanted it back when I left. I was like, nope. No.
Judge, this is Daniel.
If I could may we be excused, my witness and I, Your Honor?
You may, Mr. and Ms. Player, you may be excused at this time. So on your counterclaim with the $4,000 offset, and at this point, you'll get a copy of the order. Yes, sir.
And this we go to
Judge, Your Honor, I just
Crowell.
have one case that's not served. I'm sorry, Lou, go ahead.
I'm sorry.
I'm sorry,
Ms. Prowl, the email, the proposed order goes to Ms. Prowl?
Ms. Powell, yes.
Ms. Powell, I'm sorry. Okay. Thank you very much, everybody, for your time.
No
Okay,
problem.
well, Your Honor, so the pain and
Okay.
suffering is dismissed as well?
I'm sorry.
The pain and suffering
Yes.
regarding, okay, thank you.
All right. No, Mr. Johnson, Mr. Player, I gave you all $4,000 on your counterclaim. Now you apply it however you want to, but it's just an
Okay.
offset for the amount that's owed for the rent.
Okay.
All right.
Thank you for the clarification. Thank you, Your Honor.
Yeah. And Mr. Green, you said you had
I just have one case that's not served. It's Calvary Portfolio versus Leonia Reed. I was just going to ask for a continuance to get it served. I'm hopeful that I could just make that announcement real quick, Judge.
I'm looking for it. I have a Lasagna Bird.
Yes.
That's the one.
Yes.
Okay. We'll give you 30 days. After that, we'll dismiss for want of prosecution.
Can we get 60 on this, Judge? Is that possible?
No.
Since I waited for 2 hours. Yeah.
No.
I'm
Mr.
kidding.
Green, that's what they paid you to do.
Okay. All right.
It was not
So they
served.
paid me to do
Notice
that.
was sent, Judge. Is that what the issue is?
No, service of the underlying claim.
Okay.
All right.
Okay, thank you, Judge.
Thank you. All right. Antonio Soto Morales versus Terrence Jones.
And Judge, just briefly, just before I hate to interrupt, is there any way that we might be able to be put in a breakout room if the defendants agree, just to see if we can chat beforehand?
Which case are you here on, Mr. O'Hara? I mean, Mr.
Yes, Your Honor. It is
Mr. Dara, I'm sorry.
2024 CV 02775.
Resi Combs versus Rolita Lawrence.
I am here on that one as well. That one's a dismissal.
Okay, so I'm counting on dismissal on that. And what was the other name? Who are you representing? Because I don't. I just had you on.
Okay, that's Walden Landing versus Derek Johnson and Barbara
Dumas. All right, Mr. Johnson, would you like to speak with Mr. Dara?
Would I like to speak with him?
And see if y'all can work something out.
I'll talk to him.
Okay.
I'll talk to him. But I need to talk to you as well still.
Oh, well, if you're gonna talk to me still, then you don't need to talk to Mr. Dara.
Let me talk to him. Let me talk to him first, but there's some things that went on at the apartment, ma'am.
Okay, but Mr. Johnson, you heard the whole hearing and you heard me teach a whole class on dispossessory and eviction law. So think carefully about what you gonna tell me and how you think it's gonna affect your case. Because if you're still in the premises and you haven't paid rent, it is most likely going to be an eviction with 7 days unless they agree to more.
Ma'am, I was already illegally evicted.
Okay. All right. Well, you can talk to Mr. Dara if you want to, but
Go ahead, talk to him, yes, ma'am.
And is anyone here on Phoenix Partners versus the Trendset Beauty Academy? Phoenix Partners?
Your Honor, Michael Weinstein on behalf of Phoenix Partners.
Okay, and Trendset Beauty Academy? Last call for Trendset Beauty Academy and all others.
You can send me $35,000 today.
All right, Mr. Weinstein, do you have an order that you'd like to present?
I can, Your Honor. Your Honor, this case was originally heard back on July 31st of this year. We had entered into a consent judgment with the tenant. After coming out of the breakout room, we went back into session, announced the terms in court, told Your Honor that we would prepare the consent judgment, which we did based on the terms that were agreed to in court.
Well, if it's a consent judgment, do I need to do anything else? You can just take it for the FIFA, right?
Well, it was a consent. And so what we had agreed to was the tenant was consenting to the judgment. Right. And then she never signed off on it. So you had asked us to submit the consent judgment with the email correspondence with the tenant so that the judgment would get signed off on. And then we were told that we would appear in court today for Your Honor.
Did she sign it? Did she sign it?
She did not.
Okay, well, then y'all don't have an agreement. You have what is called a default. She is not currently here. So, did you want to prove your damages since you did a judgment of consent and that wasn't completed?
Yeah, I didn't know what your position was going to be, Your Honor, again, because we
Y'all
agreed to the
talked,
term. I'm
but
sorry.
you didn't come before me and it wasn't signed. So essentially, whatever y'all agreed to is a nullity because it was never signed and because there was no performance. She never paid anything. So if that's the case, then it puts you back into the position of having a claim. She was served, and then it's just like she never responded. Answer gets stricken. You got a default.
And that's fine. We can move to strike the answer, and we can submit a proposed default judgment, and and an order for the court to review. My understanding had been because we had agreed to those terms in court. The reason why I wanted to do that was so Your Honor understood what the terms were agreed to try to avoid the situation where the tenant then goes and does not sign the paperwork. That's how I've seen it in the past work with other courts. I didn't know what your procedure was because I've never been in front of you before,
And
Your
the
Honor.
court just says, oh, well, it didn't sign, but y'all, so what you're essentially saying is you're presenting a motion to enforce settlement.
Either way, Your Honor. I mean, we can do a motion to enforce settlement, or I can move to strike the answer, and then I could submit a proposed default judgment order. I mean, that's fine with me. Quite honestly, right now, we were trying to give her a discount on the amount that was owed. She owed about $90,000. She agreed that she'd be
You
responsible for
agreed to
60.
about 60 something, right? I
Correct.
remember.
That's right. And so we could certainly present default judgment paperwork with the ledger and ask the court to award the full amount that's owed. She did vacate the property as agreed to by August 15th. She just has not signed the consent order.
Well,
But
she was personally served. The only issue I had is Trendset Beauty Academy, which should have been represented by counsel. Is that her alter ego? It's like a sole prac, or I mean a sole owner? What's the
that would
form?
be my understanding, Your Honor. I mean, our contact was I forget the lady's name, but that was always who our contact was with. There is an LLC. She did not retain counsel. She didn't sign the consent order. She's never retained counsel. We could certainly move to strike the answer and submit default paperwork.
And Your Honor, if it helps, I don't think Mr. Weinstein was the attorney that was here that day, but both parties did come back and the defendant did verbally agree to the settlement that was made in the breakout room.
I remember. Yeah, because I remember it was like $64,000, and I remember thinking, "Oh wow, that was a lot." Well, until today, but the only issue is that if it's an LLC, she can consent to it, but an LLC has to be represented by counsel for it to be valid.
Yeah, and there was never. I hear what you're saying, Your Honor. There was never any order for her to retain counsel. And so I think at this point, obviously she was proceeding on her own. Quite honestly, I don't think she knew that she needed counsel because it was not, she was never told that. She was never informed that she hasn't retained counsel. So, I mean, and she's not here today. And I tried doing whatever I could to have her execute the consent judgment. She didn't. It wasn't because she didn't have counsel. It was because ultimately, I don't know exactly why she didn't. She actually, in the email correspondence that was submitted to the court, represented that she was going to sign, and then she just never did.
Okay, let me ask this. How was the corporation served?
Let me see. Hold on, Your Honor. It was served through its registered agent, who I believe is LaTanya Walker, who I believe is the
And she was personally served, or
she was
Tackman?
personally served.
Okay, so that gives you a judgment. So send me, and you said possession is not an issue.
She has vacated the property, Your Honor.
All right, so go ahead and send me a default judgment form.
Okay, I will do
Because
it.
they were properly served. There was personal jurisdiction because she was personally served as their representative. So even though they've vacated, you still get a judgment, whether it's collectible or not, is up to you all. But
Sure. Okay.
all right,
I will do that.
thank you.
Thank you, Your Honor. May we be excused?
Yes, you may.
Thank you.
Okay, and I'm still not getting anything on Antonio Soto Morales versus Terrence Jones. So I'm going to dismiss for warrant of prosecution. And Calvary is getting a reset, and Walden Landing. All right, so Mr.
Judge, before we move forward on Calvary, is that something that the plaintiff is going to submit, or will we just automatically put them on our next?
No, they'll just be on a calendar in 30 days. We'll just set them out 30 days to see if there's been no service prior to the calendar, then we'll just dismiss it.
Yes, ma'am.
All right. Okay. All right. So Walden Landings, Mr. Dar is representing Walden Landings and versus Barbara Dumas and Derek Johnson.
Sure.
All right.
I am here. We had just briefly spoke. Unfortunately, looks like we'll still need a hearing.
Of course. All right. So go ahead and make your case, Mr. Dar, on behalf of Walden Landing.
Yes, Your Honor. This one, interesting. The tenant was already writted out by way of a writ of possession.
Mm-hmm.
And but I will. So we're not seeking a writ of possession today.
Okay.
We're seeking just the balance and of rent, as well as the.
Okay. Was there personal service?
That I'm not 100% sure on. So
okay, if it was tack and mail, then I don't have the jurisdiction over the person. I can't issue a judgment. The most you can get on tack and mail is a writ.
And that is true. My argument is unless the defendant is here and they are here.
No.
I think that's the way I can pull that up.
No, they can. No, the difference would be if they answered. Did they answer? Because if they got tack and mail and they answered, then you would have personal jurisdiction. But if you just served them and they didn't answer and they're here because they got noticed by tack and mail, there's still no conference of jurisdiction over the person. It just would be a writ of possession.
So I think that's part of an issue here. So we weren't served a copy of an answer. There was nothing in that we had been given that there was an answer. A judge signed off on a writ of possession, and that's all we knew about until the
because if they didn't answer within 7 days, that's all a judge can do is a writ of possession. And so now, how are you suing them for a path? Because it says here you're suing them for under a dispossessory, which is separate from a civil suit for money judgments. Under a dispossessory, it's a 777 rule. Once they're served, they got 7 days to answer. If they answer, then the court has personal jurisdiction over them and can issue a judgment. If they don't answer, then the only thing that the court can do is issue a writ for possession. You're saying possession is not an issue here, but if they haven't been personally served, whether they come or not, because they could be here because they saw the tack and mail. But if they didn't answer and submit themselves to the court, jurisdiction would not allow me to give a money judgment.
So I'm looking at I only see that it was posted.
Okay. No money judgment can take place at this time. And they do have a counterclaim.
So our argument would be, Judge, if there's a counterclaim.
It should have been an answer, but you say you don't see an answer. Ms. Powell, show me what they did.
No, we weren't served a copy of an answer.
Okay, Ms. Powell, can you find an answer?
There is record of an answer that was filed on June 17th. which
you
was a
print it
month
for?
after the proceedings.
It was what?
Filed on June 17th, which was a month after the proceedings were initiated. I see that on June 10th, on June 10th, they were served by, notice was hung on the door, or service was hung on the door, and within 7 days, they filed the answer.
Okay, so they did answer, so you do have personal jurisdiction, but they also have a counterclaim.
Yes, Your Honor.
All right. All right, so tell us, what you're seeking.
Yes, Judge, if I can call China Jones, if Ms. Jones is present.
Yes, I'm here.
All right,
All right,
wonderful.
Ms. Jones, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes.
All right, you can put your hand down. Mr. Dara, Ms. Jones is your witness.
Yes, Your Honor. I'm just gonna share my screen to pull up the ledger. Ms. Jones, can you state your name?
China Jones,
All right, and what is your position at the property?
the assistant manager.
All right, and pursuant to your position, what files do you have access to?
I have access to all the files.
All right, and did you maintain a file on Derek Johnson and Barbara Dumas?
Yes.
All right. Here we are. And I have shared my screen. Can you see a copy of the lease?
No.
Judge, can you see the lease?
No. I just see everybody.
Okay.
Did you hit the green share screen?
Yeah.
Should be a green up arrow in a box.
Me too. There. Oh, hitting the share button would help.
Yeah, that one.
All right, Ms. Jones, can you see this lease?
Yes.
All right, and who are the parties to the lease?
Derek Johnson and Barbara Dumas.
All right, and do you keep a copy of this lease in the regular course of business?
Yes.
All right, you maintain this lease in the file?
Yes.
All right, and you maintain control over the files as your position as a manager of the apartment complex?
Yes.
All right, and is this a true and accurate copy of the lease entered into between the parties?
Yes.
All right, Your Honor, I haven't submitted it via email. I'm happy to do that, but at this point, I've moved to admit the lease into evidence as plaintiff's one.
Okay, I'm confused. Why does it say $18,540?
That was the 12-month period, Judge. It breaks up into installments at the bottom right after that of 15. Yep.
Okay. All right, Mr. Johnson, Mr. Moss, is this your lease that you signed? Do you have any objection to this being entered into the record of the court?
I do not.
All right, so Exhibit 1 for the plaintiff will be admitted without objection, the lease. All right, go ahead, sir.
Your Honor. Ms. Jones, pursuant to the lease, where did Ms. Johnson and Ms. Dumas reside? What was the premises for which they entered into the lease?
April 6th, 2023. Is that what you're asking?
What is their address?
Their address is 418 Walden Landing Drive, Hampton, Georgia 30228.
All right, and pursuant to the lease, what is the rate of rent on the lease?
$15.45.
All right, and when is rent due?
The first of the month.
All right, and pursuant to the lease, is there a late fee?
Yes, late fees are $100.
All right, when is rent late?
On the 6th.
All right, and I am pulling up a copy of the ledger at this point. All right, do you see the ledger?
Yes, I have
All
it
right.
pulled up as well.
All right, and on the screen, whose ledger is this?
Derek Johnson.
All right, and is this the company's ledger that is kept in the regular course of business?
Yes.
All right, and do you or pursuant to your position as a manager, do you maintain control over this document as well?
Yes.
All right, and to your knowledge, is this a true and accurate copy of the resident's ledger?
Yes.
All right, Your Honor, based on that, I'd move to admit the ledger into evidence as plaintiff 2.
All right, any objection, Mr. Johnson, to this being admitted for the purposes of examining the business records?
Yeah, I don't have no objection to that.
All right, it will be admitted as plaintiffs to the ledger.
Thank you, Your Honor. Ms. Jones, I scrolled down, the ledger appeared started from the very beginning back in 2023. Wanted to bring your attention to March of 2024. It's on the screen. Rental income. So what payments did you receive from the residents in March of 2024?
We received a payment of $1614, March 13.
Okay. And going into April of 2024, what payments did you receive for the month of April?
None.
All right. And since April through to August 19th of 2024, what payments did you receive from the residents?
None.
All right. What is the total balance due on the account through to August 19th of 2024?
$7,219.
All right. And that balance comprises late fees, utilities?
Yes, let me see. I do know in April we gave a concession of $200 for the inconvenience of the flood or whatever.
And that would be my next question, but
okay.
Answering the question is that balance comprises the late fee that we had discussed while going over the lease, as well as any possible utilities or whatnot. Is that correct?
Yes.
All right. And again, just for the court's record, that total balance
I have an objection.
Hold on, sir. Go ahead, give me the balance.
Ms. Jones, again, the total balance?
$7,219.50.
Okay, what's your objection, Mr. Johnson?
They that $200 concession they offered me, I refused that. It was $300 they offered me, and it was Amber Davis who offered it to me. I have an email I sent you all that's in evidence. The email is hold on.
Okay, so they offered you.
That's not accurate. They offered me $200.
No, they offered you $200 off the rent, and for the flood, and they also waived the $100 late fee. I saw it.
Yeah, I refused that though. If you look at my email to Amber Davis, Exhibit H.
Okay,
Exhibit H.
Sir,
You see, she offered me I'm sorry.
When it's your turn to testify, I'll take into account that you refused the $300.
Go ahead, yes, ma'am.
Okay, go ahead.
Moving on, Ms. Jones, what is your policy when rent is late?
Well, when rent is late, you'll receive $100 late fee added to your account, and then you will have to the 15th to pay the balance, or you will have the $300 eviction filing fee added to your account.
All right. So, pointing your attention to the screen, do you recognize this document?
Yes.
And what is the document?
A 5-day notice to pay rent or quit.
All right. And to whom was the document sent?
Derek Johnson.
All right. And at what unit?
418.
All right. And is this a true and accurate copy pursuant to your position of maintaining the records of the demand letter sent?
Yes.
All right. When was the demand letter sent?
It was sent out April 6th.
If you want to read that again
I meant May 6th. I'm sorry.
All right. And by what date did it provide the resident to pay or quit?
May 15th.
All right. And just reminding you of your testimony of the ledger, what payments did you receive from the residents by May 15th?
None.
All right. And at the time of this posting, were they still in possession of the premises?
Yes.
Or submission, excuse me. All right. And currently, are there any, as of August 19, were there any active work orders?
I'm sorry about that. 1 second. Okay. No, not August 19th. No.
All right. So say that again. There are no active work orders?
No, but not, no.
All right. The residents are no longer in possession of the unit. Is that correct?
Correct.
All right. Your Honor, at this point, that concludes our side. Reserve the ability to redirect if necessary.
No problem. All right, Mr. Johnson.
Yes, ma'am.
All right. Tell me, did you have any questions of the Ms. Jones? Or
Oh, I got questions for I have questions for Ms. Jones. I sure do.
All right, go ahead, sir.
Okay. Ms. Jones, did you work March 29th, 2024? Were you working?
Yes. Yes.
Are you aware of the flood that happened in my apartment?
Yes.
Are you aware that I tried to call you all for about 6 hours straight while the water ran?
That I'm not sure.
Nobody was in the office. You weren't in the office?
It depends on what time. We do have breaks that we take throughout the office.
Right.
So
Well, I called in between the hours of 2 and 5 o'clock. I called like every 30 seconds.
did you
No one
ever call
answered to.
did you ever
No
call
one
our
answered to.
emergency lines as well?
Well, I was at work, so I couldn't. My mom probably did. She's on Zoom as well. We both tried to call. No one answered the phone during that time. Amber told me she went into the apartment and was met by water, so she closed the door without checking on my mom. So you're not aware of that. Did you work July 13th? That was a Saturday. Did you work July 13th?
Let's check. I'm not sure about that Saturday. Let's see. Yes, I was here actually.
Well, I have Exhibit P. P is in Paul. If you could take a look at Exhibit P, you stuck Exhibit P on my door on July
Your Honor,
13th on the
this question's
Saturday.
on cross-examination. I think
Hey,
Mr.
Mr. Johnson, what's the question?
Well, I'm asking her, why did she put somebody else's name on something addressed to my address? She had somebody else's name on Exhibit P, and this is a notice to pay rent as well. So what notice of rent pay rent are we talking about? You got a name named Laura Parham or something like that. That's the name that you put on the notice to pay rent.
It may have
had
been
your
an
name
error.
at the bottom. Has your name at the bottom of it.
It may have been
Mr. Johnson.
Yes, ma'am.
Can she answer your question before you jump on her with another question?
I'm sorry.
Are you here to get an answer, or are you just trying to testify? Because if you just want to testify,
I want to get an answer. I want to get an answer.
Obviously you don't, because you're not listening to anything she says. All
I
right,
was just about to say my apologies. They could have been done in error, not intentionally though.
Okay.
Okay. How about are you aware? Did you work July 31st of this year? Were you at work?
Most likely, yes. It was the 31st
Okay.
Wednesday.
Are you aware that Unit 418 was rented out to someone else prior to July 31st? While me and Ms. Dumas was still in the unit? Are you aware of that?
No, because we don't rent out units to. No.
Yeah, y'all did. Y'all had my unit listed as empty. Y'all had 418 listed as empty. Maintenance man came in that afternoon about 4:30 and try
Your
to
Honor,
get.
I was on mute. I'm going to object to asked and answered on this one.
Yeah, she said she didn't know anything about it, Mr. Johnson.
Okay. But can I tell you what happened? Why I got this counterclaim? Can I tell you my whole story?
Okay, did you have any more questions for Ms. Jones? It'd probably be better if you just tell me your story, because
Yes,
you
ma'am.
testify
Yes,
while
ma'am.
you asking questions. So go
Yes,
ahead
ma'am.
and tell me what's going on, Mr.
Okay.
Jones.
On March 29th of 2024, I'm at work. I do deliveries. I'm a delivery service partner for Amazon and Courier Express. So I work the Rome, Georgia, Chattanooga, Tennessee area. I got a phone call from my mother about 2 o'clock in the afternoon, Miss Dumas, explaining to me that the carpet is wet and she don't know where the water is coming from. So I called the office. I called them nonstop for hours. Did not get an answer. So I left my post at work, drove back to Atlanta. I get back in Atlanta, I guess around almost 6 o'clock. And I talked to Amber Davis in the office, and I let her know I was trying to call all day. There's water in my unit. She said she's aware of the water in my unit. A contractor broke something outside, broke a spigot outside of my unit, and didn't tell anyone that he broke it, and went for lunch or went away for the day or something like that. I came home. Water was inches high, and that's kind of hard for water to be inches high when you have carpet and stuff like that. But water was inches high, and it met you at the door, meaning water had traveled more than 20, 25 feet through the apartment to get to the front door.
And Judge, I just object to that as speculation.
I have pictures.
Okay.
I have
Okay.
exhibits.
Go ahead,
It's-
Mr. Johnson.
It's true.
Go ahead, Ms. Dumas. You'll have
Yes.
an opportunity, ma'am, but just not like church where you get to amen the preacher.
Thank you, ma'am. I'm sorry.
That's okay. Go ahead, Mr. Johnson.
Yes, ma'am. So water was inches high. I immediately went in and checked on my mom because she couldn't walk around. She's in a wheelchair, electric wheelchair, so she can't move around. Plus, we have an oxygen tank that's in the house. So my main worry I had was water getting into the electricity and causing a spark, and the oxygen tank blowing up.
Okay.
That was a big concern of mine. Well, I get there, I talk to Amber. She tells me that Genrec, whoever Genrec is coming by and going to do stuff with the apartment. So when they get there, it's a gentleman who's a former maintenance man from the apartments, him and one of his buddies. They come in and they started moving the furniture around so they could pull up the carpet. While moving the furniture around, they broke everything. They dumped my stepfather's ashes. He has an urn with his ashes in it. They dumped his ashes, pretty much. They broke my mom's bed.
The urn wasn't sealed?
It was sealed, but they just turned everything over. It was on the TV stand. They broke the TV stand. So the urn had turned over.
Okay.
Everything was broke, ma'am. Everything was destroyed. So I had to get my mom to a hotel because we couldn't stay there. They pulled the carpets up, put the fans in, stayed in the hotel 4 days. After the hotel stay, I talked to the manager finally, and she tell me, go ahead and file you an insurance claim with your insurance company. We're gonna work with them. We're gonna work with your insurance company. So I filed the claim April the 1st.
Are you required by the lease to have renter's insurance?
I am.
Okay.
I am. I filed the insurance claim. About a week or so later, the insurance adjuster called me, denied my claim. I asked why she denied my claim. She said the apartment complex hired.
Judge, I'm going to loosely object to that as hearsay based on what another individual said who's not here to testify.
Okay. Did you receive something in writing, Mr. Johnson?
I do have an exhibit. It's an exhibit.
Okay, just tell me, did you receive a letter from the insurance company that was a denial?
I did. Exhibit
Okay.
H.
Do you have that?
Exhibit H.
Okay,
Can
can
you
you
share
tell
it
me?
on the screen?
Yeah, or can you
Yeah,
tell me what it says?
this says
What insurance company is it from?
Fortegra, and he has a
For
copy as well. They have a
Fortegra?
copy.
Judge, I wasn't
Right.
served with a copy. I could pull it up on research, but I had to pay for it.
It's Fortegra, and it states that
Well,
they
read it
cannot.
for me. Tell me what it says. Don't just tell me what you think it says.
Well, let me find it, ma'am, because when they evicted us, a lot of my stuff got thrown away.
Okay.
Also, so that's why I'm scrambling. But I got it. I got it. But long story short, they denied it, saying, well, they denied it, just saying they couldn't honor it. They just said they couldn't honor it. And talking to her personally, it goes down to
Talking to who? Hold. Talking to who personally?
I'm not gonna say what she said, but I'm
She,
gonna tell you what it boils down to.
no,
That's
Mr. Simpson. I'm
Okay.
trying to figure out what you're saying because you're trying to get around hearsay, but you can't. So you're saying that you got a denial from the insurance company.
I did.
Okay, now tell me what else happened.
I sent everything to Amber Davis, and she said she doesn't know why they denied it, but she'll give me $300 off. And I
Okay.
told her $300 doesn't even touch one day's salary with me.
What
So
were
I
you
couldn't.
asking for?
I was asking. I asked her to pay for all damages.
Okay, well,
You know,
when you say all damages, what number did you give her?
$5,404.57. The price of my beds, television stand, a pair of my Nike Vapor Max, 4 days off from work, clothing for me, clothing for my mom, antique wooden chest from the Virgin Islands that got destroyed, cleaning supplies to clean up after everything, and coin laundry.
Okay, did that also include the hotel stay?
It did.
Okay, so
It
that was
did.
the
No,
$5,404 and
it didn't
57
include.
cents.
It didn't include the hotel. Excuse me. It didn't include the hotel.
How much was the hotel?
The hotel was $168 a day. So 4 days.
Okay. All right. And so you said that you weren't able to get that covered by insurance,
None of
correct?
it.
Okay.
Correct.
And you said that the credit that you were offered after the flood was $300.
Correct.
And you said that you denied that credit, but but it appears to me that they may have applied it anyway.
Well, they applied 200 of it. So they
Well,
even
no,
went back
no.
on the extra 100
So
that they.
what I saw was a credit for 200 and then a late fee waiver of $100.
Okay.
Did you see that on the ledger? Do we need to go back?
I did. I did. I saw the 100. I saw the 100.
Okay. All right.
Okay.
All right. So now, go ahead. I'm sorry.
Also, when they came into the apartment to get the rugs up, they put a hole in the wall because they had to repair the spigot from the outside.
Okay.
That's exhibit B.
Did
Look at the
they
hole.
ever repair the hole in the wall?
August 2nd.
So they've repaired it, but it wasn't until August 2nd.
Wasn't until August 2nd. After, well, I'll go into explain. So we go back and forth about the rent and the money or whatever.
So
I told them
let
I'll
me
go to
ask you
court with
this.
them.
Let me
Yes,
ask
ma'am.
you this. At the point that you had all this happen, did you stop paying the rent?
I did.
Okay. And when you stopped paying the rent, did you attempt to move out of the property?
No, I actually planned to stay there. I wanted to go to court and get it over with and get back to living out there because my mom was
Okay.
comfortable out there.
But did you understand what I explained when I explained in the previous hearing?
I
That
do
you got
understand.
three options. You can wait, you can give them notice and they fix it, but you're still paying the rent because you're in the property. You can bring somebody in to fix it for you, or you can fix it yourself, and you can pay those things and get an offset on the rent, but you're still paying the rent because you're in the property. Or you can claim that the property is uninhabitable because you can't comfortably live there, and you can leave and claim constructive eviction. So it looks like you stayed in the property but didn't pay the rent.
That's correct.
And we learned earlier that that's not proper under Georgia law.
Right, but also under my lease provisions, I can't do any alterations or do anything to the apartment as far as fixing anything. That's in my lease.
Okay.
That's in the lease, ma'am.
Okay.
So I can't fix things.
Okay.
So I found my answer.
Uh-huh.
I filed my answer. You know, the sheriff came by. I filed my answer. In the middle of finding my answer, I'm keeping track of what's going on online with the court case.
Okay.
So I see there's a writ of possession application that's been applied for on July 12th.
Okay.
And I was questioning that for months, wondering how can a writ be issued and I haven't went to court yet. So then July 12th, July 13th, I get something else posted to my door with another person's name on it for a notice to pay rent.
Okay.
The name on it is Laura Parham.
Okay.
I don't know who that is or whatever, but it was on my door too.
So are you saying that you never received anything in your name or your mother's name requesting that the rent be paid?
I did receive it. I did receive it, but I received two. I received one in my name, and I received one in somebody else's name.
Okay, so let's assume that you know that you're not the other person. Let's focus on the one that you received in your name.
Right. So I took the appropriate steps. I filed my answer.
Okay.
And waiting on court to come, and then July 31st, about 4:30 p.m., maintenance men coming to my apartment saying they getting the apartment ready for the next tenant. And I said, well, my mom, she's there now. She could tell you more about that.
All right. Mr. Mom?
Yes, ma'am.
Okay, go ahead and tell me what happened.
I was flabbergasted because I didn't know anything about that. And I'm, wheelchair bound with oxygen, and, what could I do?
Okay, let me ask you this.
Hold on,
Mr. Johnson.
I'm sorry, ma'am. I'm sorry.
Please. I've been doing this a long time, so there's certain questions I have to ask you in order to figure out what I need to figure out. The first thing is, did they have a provision in your lease that says they have to give you a certain amount of notice prior to coming into the apartment?
I don't think they have a provision, but we got certain circumstances going on with my mom. Just like, she has oxygen, and I've been asking them since we moved there to put something at the door saying oxygen is in use, and they never did it as well.
You couldn't print up a sign and put it on the door that says oxygen is in use?
I mean, I probably could have, but it says in their lease that they do that.
But if they didn't do it, Mr. Johnson, and it's important to give people notice that your mom is on oxygen, why didn't you just put up a sign?
You're absolutely right, ma'am. I just questioned them about it.
It just drives me crazy that people just think that, that the stuff that is going to get done when the landlord fails to do it, but it's essential, y'all don't do it. It was like, well, we just stayed there with wet floors and breathing in wet air because the landlord didn't fix it. At some point, you got to take responsibility for yourself. I mean, once you get to court, it'll all shake out. But if your mom has certain needs that they can't just have somebody coming in and out of the place, you can put a sign on your door. Why wouldn't you do that?
Well, they knew. They knew her condition. They knew that coming in.
I get that, but if they hire a vendor, they're not necessarily going to remember to tell that vendor, hey, if you go to this place, there's a lady who's in a wheelchair on oxygen. Now, but let's get back to it. So on 7/31, they came into the apartment at 4 p.m.
Not
What
the vendor,
happened?
not the vendor, maintenance men. They work for the apartment.
Okay.
They work for the apartment, so they understand, her situation. They've had dealings with her before, with my mom before, so they know who she is. But they came into the apartment saying they getting the apartment ready for the next tenant. I called the office and talked to Yolanda, the manager. Yolanda looked in the system and told me, "Yeah, excuse me, Mr. Johnson, we did rent your apartment out to somebody else. Let me go into the system and fix that. Don't worry about that. Let me go into the system and fix that. I got it covered. That same night, ma'am, a lady came and knocked on my mom's door. I was school shopping with my kids because it was back to school. My mom was home alone. Somebody knocked about 7:30. She called me, asked me, was I expecting anyone? I told her no. She said, well, somebody knocking. I was like, well, don't nobody have no right to come in. If anybody come in through that door, Mom, you blast them. Told her just like that. About an hour and a half later, my mom's cell phone rings. I pick it up. It's an Officer Cody Cornell with the Clayton County Police Department on my mom's phone. So by this time, I'm going berserk asking what's going on. He said, there's been a mistake. He tells me, some woman comes to my house with a locksmith, cuts off my locks on my door while my mom is at home on the phone with 911. I have the 911 audio. I started to submit it in the evidence. I can email it to you right now if you want to hear it. But came into the apartment saying that she rented the apartment and had the locks cut off. Come to find out.
Okay, hold on.
Damn.
This was somebody from the
I don't know
landlord?
I don't know where they came from.
Because somebody who's leasing the apartment wouldn't have the right to cut off the locks. They would have to get a key from the
office was closed. It was closed. It was after closing hours. On the same day she told me she rented out my apartment.
Okay, but even still, they usually wouldn't have somebody come with a locksmith after closing hours. That wouldn't make any sense.
You gotta talk to my mom. She's right there. It happened while she was there. And I got a police report included in the evidence too. The police report. It's in there.
Right. So they come and they attempt to cut off the locks. What happened after that?
They cut the locks off.
Okay.
Go ahead, Mom.
They did cut the locks, and I was frightened to death because I'm in there alone, and somebody drilling the locks off my door. And I look through the peephole, and I see three people. I see one white man, and a tall black man, and a black young lady. And I didn't know what to do, so I called 911 and reported a home invasion.
Okay.
And the operator was really nice. She told me to go somewhere and hide in the house. I had a pistol, but I didn't want to shoot anybody. But I was told later that I should have. But yeah.
Probably good that you didn't listen to that, ma'am. Okay, so after the police came, what happened?
They caught the people because they came in the house. They got the lock off and walked into the house. And I was in my room in the back trying to hide. And I kept telling the operator that I was afraid, I was scared, and that I was on oxygen. And I was, my breathing was labored because of the excitement and the tension.
Okay.
My breathing was labored. And they wanted to take me to the hospital, but the hospitals can't treat panic like I was dealing with. unless they gave me medication, and I'm on enough medication.
Okay.
But they sat there, they found the people outside when they pulled up, and they questioned them. And I think my other son came until Derek could get there. Then Derek came, and they were outside.
Okay, Mr. Johnson, did you become aware at any point of who it was, or if it was somebody who was just breaking into the house?
I'm trying to get warrants on them as we speak. But yes,
okay. No, sir. Did you become aware of who it was? Was it somebody from the property management, or was it somebody who had no
dealings whatsoever? I don't know them from a can of paint.
Okay. So it was not property management that was trying to break into the house?
No.
Okay. All right.
It was somebody else. So anyway, we did the officer, when that was going on, we were trying to contact people in the office because that person was saying they rented the apartment, and the police were trying to figure out why were we in the apartment that they rented.
And Judge, I'm just going to object to what someone else.
I got you. All right, so Mr. Johnson, Miss Jones earlier alluded to there being an emergency number that you could call. Did you try calling the emergency number because you were home at that point? Huh?
Called the emergency number. We did.
Okay.
The maintenance man came over, just the maintenance man, nobody else. But he tried to call the manager. She wouldn't answer the phone. And then all of a sudden, the courtesy officer comes over, pulls up on the scene, and he changes the narrative of the whole thing. He charged them with trespassing.
Okay.
And, I know why he did that.
Okay, well, so, okay. All right, so at this point, we've resolved the fact that there was somebody trying to break in. You've talked to management and maintenance. What happens after that?
The maintenance man put the locks back on. Yolanda calls me the next day, telling me she has nothing to do with what happened the night before. Is that hole still in my back wall in the unit? She could send someone to fix the back hole in my unit Friday, or whatever the case may be. But it didn't happen until Monday. But she did send somebody out there then. But and then she said, yeah, I see you got a case still pending in court with us, so we'll get that resolved and blah, blah, blah. That was that.
Okay. So at any point, did you resume paying the rent after the flood?
I did not.
Okay. All right. Anything else?
Yes, ma'am. So August 19th, I left to go to work. I get a phone call about 9:30 saying that the sheriff's at the house. So I let me talk to the sheriff. So I asked the sheriff, I said, why are you evicting me? I haven't had my day in court yet. He said, well, I got this writ. I said, what's the case number? He said 2024 CV 02775. I said, how you evicting me on that when I haven't went to court yet? He said, I don't know, you gotta take it up with the judge. I only enforce it. So here we go. I went to I did a complaint against the sheriff department. I talked to a Captain Franklin. He sent me an email of the writ. The writ he sent me has no sheriff entry service written on it at all. I have two different writs. I have one that's written on, I have one that's not. The one that's not written on is the one that I was evicted on. Probably. I don't know. But I was evicted and I lost everything. I lost a watch collection, lost all my televisions because your sheriffs have a black Chrysler 300 riding behind them, scooping up everything as they evict people. And my mom out there by herself, they took everything. They took everything. Everything I replaced from the flood was taken, or was taken basically. TVs that wasn't in the flood. They were up high, but they were taken too. All my TVs were taken, all of them. I got the remotes, but I have no TVs. And other stuff. There's a lot of other stuff missing that I can't put my hands on because, just had had so many things. My mom had her things. Everything was placed outside in the parking lot.
Okay.
For everybody.
Did you ever get a notice from the sheriff's office on your door or handed to you personally about the eviction? Like I know you got the notice to quit the property, but did you get something from the court, the magistrate court of Clayton County?
Never. It's not even in your filings. With your case filings. Never got it. Never.
Okay.
Never.
All right. Anything else, Mr. Johnson?
I guess that's let me see. Go over my notes. So the people at the apartment complex had Genrec. Since they're not an actual company, the property hired them. So that's an employee-employer relationship.
I'm not certain what the relevance.
Oh,
right.
The relevance.
So hired them to do what? I'm sorry.
Hired them to pressure wash the building. He was out to pressure wash the building. Just my building alone, but my building had mold on the outside of it. So at first they thought it was dirt. So they were going to pressure wash it. So he was out there trying to pressure wash it, and he broke a spigot while it was on. And the spigot that was on was running in my house.
Okay,
it connected to my wall.
Yeah, I didn't see them claiming that that somebody connected to the company wasn't the cause of what happened. Okay, so
I inquired about getting the company's information, and she wouldn't give me the company's information. Nobody knew the company's information, so I looked them up on the Secretary of State's website, and they're not there.
So there's two things going on here, Mr. Johnson. So the first thing is the flood and I guess whatever might have happened related to the flood, the things that you lost as a part of the flood, and the fact that I don't know, did you file an appeal with your insurance company as to why they didn't?
They dropped me soon after, ma'am.
They dropped you?
Soon after. Filing a fraudulent claim. They dropped me because they told me the apartment complex knew good and well, since they hired them people, the way they hired them, they're responsible. They're not responsible for them hiring somebody who's not a licensed contractor.
Judge,
so I don't have that.
All right, Mr. Dara, the issue I have though is if he is required to have rental insurance as a part of the lease, and somebody from the apartment complex tells the insurance company that his claim is false, then how can he recover for something that he's required to have?
I think that would, that's a good question, Your Honor. I think that if Mr. Johnson was able to have somebody here to testify from the insurance company or have a document showing what the things that he's saying, we'd be better able to flesh that out. As it stands, we don't know the reason for a denial.
And we're okay with this.
At least that's not in evidence. Not necessarily, Judge.
Ms. Jones, do you have any idea why the insurance company would have denied his claim? Did you say anything to them?
Honestly, no. I was not the person who may have spoke with them.
Who was the person who may have spoken with them?
Honestly, I don't know. I wasn't aware of anyone speaking with them, so I'm not sure.
It was Amber Davis.
Okay, and then the second thing that's going on is they may not be ultimately responsible for the eviction. And the reason is there were some issues with magistrate court where writs had been signed when the actual process hadn't taken place. So I'm aware of it because I got an email about it. Like, hey, if you get some cases, make sure you check to make sure all the I's have been dotted and crossed, because some writs have been signed and some people have had evictions that hadn't gotten to yet. So I get that, and you may be one of those people. I'm having people here look that up, and if so, then your recourse is with magistrate court, not us, because and maybe not the company. If they file an eviction, there's a process that goes on with the courts, and only a judge can okay a writ of possession. If a judge okayed a writ of possession that shouldn't have been okayed, then that's not their fault. That's the magistrate court's fault. So when they came to evict you, did they give you any documents, like a writ of possession that would have been signed by a judge?
No, but I have two. Like I said, I have two different writs. One of them is not signed, and it has the sheriff's entry on it. The other one is signed with no sheriff's entry on it. The one that's signed has your signature on it.
My signature. Oh, wow. This just gets worse and worse. Yeah, that looks like my signature.
Right. It has your signature.
So there was a sheriff's entry of service on one, and then Ms. Powell?
I have two. I have two sheriff's entry services. And I talked to Captain Franklin already up in the sheriff department. He the one that sent me the one with your signature on it.
Okay.
He sent me that one.
What
the
date
one that
was
I got? It was October, hold on. October 7th, he sent me that. But this has July 12th on it.
Is the date I signed it?
July 12th.
And you never got anything tacked on your door?
Not at all, ma'am. Not at all. Only thing I got tacked on my door, the one from China saying Law Parham, a different lady's name, somebody who doesn't even live here, live at the address.
What's the case number on the one that you say I signed?
Same case number, 2024CV02775.
Okay. Ms. Powell?
Yes, ma'am. I'm looking at this now.
Okay, hold on just a second.
Yes, ma'am. And I can send you that email if you want it.
What's the email from?
It's from Captain Franklin, where he sent me the writ.
Okay, hold off on that for a second.
Okay. And I found the insurance paper too, the letter from the insurance company.
All right, Mr. Johnson.
Yes, ma'am. I found the insurance paper too, the letter from the insurance company.
Okay, can you read it to me?
It says, in reviewing your claim, the physical damage to your personal property was not caused by a peril insured against your policy. Since the damage was not caused by a peril insured against, there is no coverage for the damage to your items. For your reference, we have listed the perils insured against below. And they have a whole list of what they cover. Number 12 says accidental discharge or overflow of water or steam. It says that. It says water. But the reason why they didn't honor it is because of who did it and his position while he was doing it.
Okay. All right. So let me I've looked this up, and I think what happened was there was a mistake, and it was probably a mistake on my part because, like you said, you had one writ with a service, one writ without a service. And so let me just
I was trying to get in touch with you to have it switched, but I couldn't get in touch with you. But go ahead.
Okay.
To get it
From
fixed.
a legal standpoint, for not paying the rent, you haven't presented an argument or defense to stop possession, but that's separate from your counterclaim. Yes, because the counterclaim is separate. There's the damage to your property was caused by either the Walden Landings or an agent working for Walden Landings.
Correct.
So I haven't heard any objection to that. Now, the fact that your insurance did or did not cover the claim, it seemed that they should have, because one of the perils that they list should be what seems to be a discharge of water or steam, and that's what happened in this case. But what I need to hear from you is, like you said, you gave me a $5,404.57 for broken items and a 4-day hotel stay. Did you have pictures or anything of the damage that you had due to the release of water?
I sent you probably about 20 exhibits.
Okay, when you say you sent them to me, did you file them?
To the clerk. I filed them with the clerk.
Because I have the paper exhibits, but I don't see pictures.
Oh yeah, I gave you definitely pictures.
Do you have pictures that you have?
I even brought some on the 22nd also, some more pictures.
Okay.
On the 22nd of this month. But I have pictures. Here's the broken bed. That's what they did when they broke the bed.
Okay, hold on. Slow down now. Slow down.
I'm sorry, ma'am. I'm sorry.
I'm gonna pin this so that everyone can see. Remove all pin videos. Okay, yeah. All right. So whose bed was that?
My mom's.
Okay. And do you know the amount of that bed when you bought it?
And receipt is in here. Here's the receipt.
All right. And how much did you?
Hold
on, slow down. You moving it. I got to figure out.
I'm having a hard time with the authentication of this and where it was purchased, when it was purchased.
I haven't asked those questions yet, Mr. Dar. If you want to ask them, you can.
I was just objecting to the introduction of these things, but I'll let Your Honor move forward.
All right. So, Mr. Johnson, so how long have you and your mom been, New York? Your mom has a New York accent, I think.
We're all from New York. I've been here since 1996.
Okay. So, and you've been living in this property since when?
2023. My mom had some health issues. She was perfectly healthy a couple of years ago. And
okay, I get that. So when
she had to move down here with me.
I got you. So when you moved into Walden Landings, did you purchase that bed new, or did you had you purchased it since you moved or before you moved?
Before I moved.
Okay. And what size bed was it?
A queen.
Okay. All right. All right. Show me some more pictures.
Okay. That's the hole in the wall that they just fixed August 2nd. That was in the bedroom, leading to the outside.
Okay, did they finally fix it?
August 2nd,
Okay, whose room was that?
my mom's.
Was she able to stay in that room?
Not really. Not really, no ma'am.
Okay,
That's some
all
of the
right.
rug that was wet. That's some of the carpet that was wet. You see how dark it is? That's water.
Okay, all right. Show me something else.
That's my mom's closet. You see all the water in there in the closet?
Yes.
Okay. That's leading in the hallway. There's more water in the hallway on the carpet.
Okay.
That's the TV stand they broke. This picture and this picture are the TV stand they broke.
Okay, so they broke it trying to move the stuff out of the
Trying to move it.
property?
Right. Trying to move it out to get, try to move it out the way so they can pull the carpet up.
How much
All-
how much did you pay for the TV stand?
Let me see.
Do you know where you got it?
Yeah, from Wayfair. It was $6.99.
Okay. $699?
It was, yes, ma'am. Got plenty more. Hold
Okay.
on. This picture right here, that hole in the wall in the closet that I showed you.
Mm-hmm.
This is the outside. This is the outside spigot that he broke that leads to that hole in the wall. That the contractor broke. That what he broke outside.
All right.
And that's where the water came from. I have here's the water Amber Davis was talking about at the front door. As soon as you walk in the front door, that's a wooden floor.
Oh, I was
You see
going
how
to say.
much water? That's in black and white, but it's a wooden floor.
Okay.
So you can see how much water is on the wooden floor. That's by the front door.
Okay.
That's my mom's oxygen tank that I was speaking of, that I didn't want to blow up.
All right. Well, what did you think? Okay. All right. Go ahead.
Here's some of the carpet being pulled up. There's one man doing the carpet. So of course he's dragging everything across the floor to get it out, to get it off the carpet. He's dragging everything. There's one man doing the carpet. So any kind of heavy furniture, he has to drag. Here's the contractor outside the day after the flood. The flood happened on a Friday. Saturday morning, I came to the apartment to check on the apartment. This is him outside of my building, starting on something else all over again. The same guy who did the damages.
Okay.
When I showed him the inside of my apartment, he packed up and left. He didn't even do no more work. When I showed him the inside of my apartment. They said there wasn't any work orders. All the work orders have been completed. Here's a work order from last year that I did online that still hasn't been done.
Okay, does this have to do with the water?
No, ma'am. It was something completely different, but it still hasn't been done.
Okay, it says something about cats.
It's before the water, right? Cats all over the apartment complex, everywhere.
Oh, okay, but I'm not.
They run your patios, and dogs. People in the apartment complex got dogs messing all over the grass, all over the sidewalks.
Okay, but I'm kind of focused on the water damage right now, Mr. Johnson.
Okay, I'm sorry. Yeah, so there's.
Was there any other items of furniture that were damaged?
Clothing, shoes, and stuff like that.
Okay.
There was clothing that was there. You know how, like me, I leave a lot of clothes on the floor. You know what I mean? I just do. And a lot of that stuff I could wash, but some of my shoes I couldn't wash.
Okay.
After they pulled the carpet up, they didn't pull all the carpet up. They left the carpets in the closets.
Okay.
And I had a big gnat problem after that. As you can see, this is Zevo. I had to keep Zevo in every room because of the gnats.
Okay.
Here's some damage to them. Here's some shavings from my door from when they cut my locks.
Okay, but that's their damage.
Right.
That's not your damage.
And that's the guy fixing the August 2nd. That's him in there fixing the hole in the wall.
Okay.
See what else I got here. Yeah, everything else I got for other purposes, I guess. Some of the stuff got thrown away, you know.
Okay.
I'm lucky to have this
Black
as I do.
credenza, that black credenza that was in the living room.
I already showed them that, Mom. I showed her that. I showed her that.
All
But I was
right.
asking, you know.
All right. And you said you were in a hotel, the two of you, for 4 days?
Right. Friday, Saturday, Sunday, and Monday. Came back home Tuesday because she said she had somebody who was coming out to do some work on the apartment Tuesday, and they never showed up.
Okay. All right.
I missed a lot of days from work too. I missed about 5 days from work based on this.
Okay, why 5 days? Because once you secured a place to stay, why did you miss work?
Because of my mom, she being in the hotel, she couldn't move around. She didn't have a chair. Her chair weighed 400 pounds.
Okay, where was the chair?
It was in the apartment. It was wet. It couldn't move. Had to be replaced.
So her wheelchair, her motorized wheelchair had to be replaced?
Had to be replaced. It didn't cost us nothing, but United Healthcare, took care of it. But
right,
it was hard getting, I couldn't leave her with no way of getting around and being in a strange place, couldn't cook, couldn't do nothing for herself.
Okay, and how much do you make per day?
500 and some change. I charged them 300 because I thought they were working with me when I did the insurance claim. So I just put 300 a day. I make 500 a day.
Is that commission or is that your salary?
I own my own business, ma'am. I'm a
Okay,
delivery service partner.
So you do a contract.
That's what I bring home every day. I got a contract. My contract, I have 2 contracts. One contract is for a certain amount a year. The other one is for a certain amount of deliveries.
Okay, so when you do deliveries, that's what you expect to bring home every day.
500 every day.
Okay. All right, Mr. Dara, did you have any other questions for Mr. Johnson?
No specific questions for Mr. Johnson at this point.
Okay. So, Mr. Johnson, initially for the totality of the broken items, you claimed $5,404.57.
I claim 15,000. If you look on the correct, I claim 15 altogether for everything. For that,
Okay.
and then I claim. Go ahead, though, ma'am. I'm sorry.
No, I'm just asking because I didn't hear 15,000. I heard 5,404.57. That's what I heard.
That what I put as far as my clothing, my furniture, and stuff like that. But I claim 15. I claim 15, and I claim 8,000 in legal expenses.
Who did you consult for legal expenses?
Myself. My time is valuable. My time is just valuable. I have to do all this work myself.
Mine is too, sir, but you don't get to claim to be a lawyer when you ain't a lawyer.
No, but I had to pretend to be a lawyer today. And every other day I did all this work myself, man. I did everything myself.
That commercial where they said, that's not how this works. That's not how any of this works. Those little old ladies on TV, when they say that, that's not how this works, sir.
I had to make copies, had to do research, had to research the laws on the landlord tenant, the landlord and the contractor and property owner. Had to look up all these laws.
I got you. You have done all of that. Let me see. I
had to read 44-7-20 3 times. I had to read 51-2-5 several times.
Well, I'm gonna say this: you probably make more money doing what you do, but if you want to go to law school, we would welcome you.
And then I got something from you all saying something about some military stuff. Like
No,
we didn't
that
claim.
means, so what it is that for people who are in the military and they may not be able to respond very quickly, like
Okay.
they're on temporary orders and they're out of the jurisdiction, or they're
Okay.
overseas temporarily or out of the, away from their space. There's a requirement that the person suing has to check a database to make sure that this person may not be entitled to more time because of their military service. So that's all that is.
Okay.
When I've done my calculations based on what you gave me, it comes to $8,576.57. That's the 5 days of work at $500, the $5,404.57 that you claim for the broken and damaged items, and then the 4 days in a hotel, $672.
Okay, how about the emotional distress and the insurance, having them give me the runaround for filing this insurance thing and know good and well that it wasn't, they knew I shouldn't have filed the insurance claim. They knew they were responsible, but they tried to throw me
Judge,
for
I'm
a
going to
loop.
object to that. That's and
Mr. Dara?
And Your Honor, I would just object to these particular numbers. There's no receipts or evidence that's been presented. There's no
It showed a receipt and you objected to it.
for one of the receipts. That's right. But there's been no other. I objected to it for lack of authentication, not necessarily. I just don't want him to show any receipts. Just a lack of authentication as to when it was taken. I didn't see a store name. I didn't see a title. What it was for purchase.
There's a store name on it.
Hold on,
I
Mr.
don't
Johnson.
see a wage.
Mr. Dar, here's the other thing. So if there was a flood in your house right now, you could give me receipts for everything that you purchased.
No, Judge. I'm just saying that while we're just saying numbers, and if Your Honor is taking into consideration these various things, I would like the court to take any kind of depreciation based on some of these.
That's why I asked about the bed.
Yes, Your Honor.
But when you have two people living in a place where clothes, shoes, beds, there's a hole in the wall that goes to outside. He said he tried to mitigate his damages. He washed some of the things, but you can't wash shoes. Certain things, once mold sets in, you can't wash that. Things were moved around, broken, damaged because they were sending somebody in there to try and get the carpet up as quickly as they could. So I don't find these amounts really unreasonable. I understand that Mr. Johnson stopped paying his rent, which shouldn't have happened, but that doesn't mean that he's not entitled to damages for what happened when he had a flood in his home. Now, the rest of the stuff, somebody trying to break in, I'm not sure the origins of that at all. It may be that somebody screwed it up, but it would seem to me that if the apartment is going to be rented, the person would come in and view the apartment prior to just saying, you just going to give me an apartment number and I'm going to move in. I think when you're leasing, people are entitled to move in and to look at their place they're going to move in. I could be wrong. Ms. Johnson, is it y'all's custom to just say to somebody, hey, we'll put you in a 3-bedroom and that's going to be a unit 417? Or do people view apartments before you rent?
That's Ms. Jones, Your Honor.
I'm sorry, Ms. Jones.
We don't lease apartments we don't put prospects on units that they're already occupied. We don't do that. Now, what we do is.
What I'm saying to you is when somebody comes and says, Mr. Johnson, hold on. When somebody comes and says, I want to rent an apartment and I need a 3-bedroom. So do you take them to show them the available 2 bedrooms?
Yes.
And then that's what they would choose from? Or do you say, hey, I'm going to show you a 2-bedroom, but we're going to give you a different 2-bedroom?
It varies. Typically, we show them what they'll be moving into.
Okay.
So honestly, even with that situation, from the only thing I knew about the lady was that she had dementia or something like that. I'm not sure. I don't
Okay.
I don't even know where that came from.
All right. So yeah, that doesn't concern me as much as the flooding and the fact that he's required to have insurance for his lease, but the flood wasn't occasioned by him. And then when his insurance denied him, that still doesn't mean that he wasn't damaged by the flood that came into his home.
And
All
just
right.
some respect to see if Ms. Jones had anything to mention, because I had reserved that earlier, and just
Yes, you did.
Jones and Ms. Jones, if you have anything to add to these statements that were made about the flood or items being removed.
Yeah, okay. So I was gonna ask for, I know you said like the bed was broken. Did you ever replace it, or was it the same bed that was?
I definitely replaced it, but it got put out, so all my stuff is not intact. Everything
Right.
that you
Well,
all
I
put
would
out on the
say,
19th.
what I can say, the day of eviction, we all were here. We did, well, I know, I'm not sure who reached out to you, but someone did reach out to you to let you know. They told
I
you
called.
early enough to, so you could get there, because we did notice
Well,
the
Miss
notice that
Jones,
your mom
Thank you,
was
Ms.
early
Jones.
there.
Thank you,
enough
Ms. Jones.
is Miss Jones, early enough is subjective. If he works in Chattanooga, then
Right.
early enough may not
Well,
be early.
I wouldn't say enough, but we called early.
I got you.
And we waited, like we said we was gonna take, they did a really slow eviction just because they knew that his mom was there.
I got
She stayed there the entire time of the eviction, but we also saw Mr. Johnson come to the apartment complex with his U-Haul. So I was kind of
Right.
confused on how were the items, because they made sure all your items was put right there in front of the actual unit.
But Miss
We saw,
Jones,
Thank you, Ms. Jones. Thank you, Ms. Jones.
the point is that I'm not at that part. I'm at the part where his initial items were destroyed. I'm not at the part where he lost things due to the eviction. I'm at the part where his apartment was flooded, and then when he made a claim for his insurance, the insurance claim was denied. He didn't occasion the flood. He didn't do the work that caused the flood. There's been no documentation or any evidence that Mr. Johnson caused the damage to his items. So he's entitled to recovery for that, if nothing else. I'm not concerned past that point with respect to the counterclaim, because this is the counterclaim that he filed. So, Mr. Dar, did you have anything else at this time?
Nothing further on this, Your Honor.
All right. Did Mr. Johnson, you said you had something else?
I just wanted to say I never looked at my apartment before I rented it. They never they said it wasn't ready. And even when I moved in, they said it still wasn't ready, but I had to took my mom from South Carolina all the way to Atlanta, and I needed to put her somewhere. So I had to put her in the hotel, then clean the apartment, exterminate it, and do all that stuff myself before I moved in. So no, I didn't look at the apartment first.
Ms. Jones did acknowledge that they do both ways, but the fact that somebody came and tried to drill a lock and then they repaired it, I get that. But there was no actual damage to you at that time, and you need actual damages for emotional damages. So had they come, hold on, when they drilled the lock, had they come in and damaged your property in any way or hurt your mom in any way, that would be separate. You could claim those actual damages, and then those could lead to emotional damages. But without actual damages, you can't get emotional damages. That's how the law works. It's not I didn't write it.
I have another question.
Yes,
the actual damages should come in at, because the front gate is never open. I mean, never locked. She got through the front gate. She got through the front gate without having to use a key card, because the gate never works.
Okay, that's separate, sir. That's a separate claim. All right. All right. So at this time, if I got my numbers straight, the balance through August of 2024 was 7,200. It's going to be about a wash, unfortunately, because they're entitled to whatever the amount was through the date that you were out of the property. So that's $7,219.50. The court is going to award you $8,576.57. So you'll get the difference on your counterclaim. Let's see, $7,219.50 minus Sorry.
Who pays this and when do I get it?
Hold on.
Yes, ma'am. And I'm still filing a suit, China.
You've already filed suit, sir. This is your suit.
Now, there's another one.
Okay. All right, so you're as the amount that is outstanding, the plaintiff owes you on your counterclaim $1,357.07, and that's the offset. The plaintiff is entitled to the total amount pled of $7,219.50. The court is going to award you $8,576.57 on your claim, and the difference is what the plaintiff will pay to Mr. Johnson and Ms. Dumas of $1,357.07.
How about my security deposit that I put down on this apartment?
I don't think you get your security deposit back if you're evicted, sir.
Even though I evicted illegally?
You weren't actually evicted illegally. The process didn't go the way it should have, but you didn't have a defense for not paying the rent.
But I wasn't supposed to be evicted until maybe a week after today.
I got you, sir.
Right. So that's the big thing.
So you'll get $1,357.07.
Okay, who pays me that? Walden Landon? When y'all paying Walden Landon? What my money?
Miss Powell will do the judgment order in this, and we'll make sure that both sides get the order. Okay.
And Your Honor, in the order, can we indicate that Walden Landing is not responsible for the set out or the eviction?
Oh, definitely. I will definitely indicate that. Please, Ms. Powell, please put a note.
He worried about that eviction, but boy, I got you on that.
Well, I mean, in fairness, they're not responsible for it. We messed up. And it was because one of the documents said that you had been served in the service document, and then one of them said you had not been. And so somewhere in the process was an issue with the certifying the sheriff's entry and whether there was an answer due or not. And so I'm going to take that one. That was on us. So Walden Landon is not responsible for the set out.
But they're responsible for that gate being open and that woman being able to come into that gate with that locksmith and everything. They're responsible for that.
That's very different. I don't have, that's not something that I'm going, sir, I'm not going to litigate that. So that's separate. So if you want to file suit about that, that's
I'm definitely filing suit. That's what I was trying to tell the lawyer earlier. That's why me and him may need to talk.
All right, that's fine. That's fine, sir. But judgment, okay. Listen, judgment for Walden Landing for their judgment claim, and judgment for Mr. Johnson and Ms. Dumas on their counterclaim, which led to an offset. And we'll prepare the order and we'll make sure everybody gets it. Okay.
Thank you, Your Honor.
All right. Thank y'all, everybody, for your patience. This took a little longer than I thought, but I had to hear it to understand where the issues were. And I appreciate you all for your patience. All right. So individuals who are here for the 1 o'clock calendar, thank you for your patience. But video court allows you to do some other things while you're waiting to be heard. Now we'll call the 1 p.m. calendar. Everybody else is, if you have had your case heard already, you're free to go at this time. All right, so Imalede Carrillo Tua versus Reginald Denoris Kemp.
Yes, Your Honor. Elena Felgen on behalf of Imalede Carrillo Tua. We were called here on a damages hearing following a default judgment.
Yes.
I tried to speak with someone at your office. The defense has filed a request for jury trial on damages here. So I don't believe that we are able to proceed on this hearing today. I've tried to kind of communicate that to your staff, and unfortunately I was not able to get.
Okay, I'm sorry. You didn't have our email addresses?
No one would give me it. And every time I talked on the phone to anybody, they told me that if the judge decides to cancel the hearing, she'll let me know, stop calling, basically.
Okay. Okay, that probably was the clerk's office. Yeah, I think our email.
Your chambers, Your Honor, specifically called your chamber.
Okay.
I don't want to badmouth. I won't list names, but
No,
just,
that's all right. Let's see. Because our email addresses should be on the website.
they didn't have an email address for your staff, unfortunately. I could contact the clerk, but they would not.
Okay.
Whoever
Well,
answers the phone at your chambers would not give me an email address.
okay. Well, we will fix that and make sure that the email address is available. And it should be
Appreciate
also on our notices. All right. So we'll go ahead and put that on the jury trial calendar. And you all will appear for a pretrial conference in the later. Because my understanding is there's no discovery to be had.
I answered their discovery that they sent to me out of my good graces. But yes, I don't believe I don't know whether they have a right to depose my client on damages or not. I will let Your Honor speak to that, but I would object to any discovery on their part on that.
All right, sounds good. Well, then I'll look to put you all on a calendar because if it was ready for a bench trial, it should also be ready for a jury trial.
I appreciate that, Your Honor.
You're welcome. Thank you. And I'm sorry for any frustration that you might have had.
No worries. May I be excused?
Yes.
Thank you.
All right. So HMI Atlanta 2 LLC versus Meyer Enterprises, Inc. This is a contract claim.
Yes, good afternoon, Your Honor. Kimberly Reeves on behalf of the plaintiff. And we are ready to proceed on our motion for default judgment. We've had no contact from the defendant whatsoever.
Okay, and the Meyer Enterprises was never represented by an attorney?
I've never spoken with an attorney on their behalf. I mean, they were served with process and they never answered. So the matter is in default and we're here to just present our motion. And I've got a witness if the court needs to hear testimony on the damages.
All right, served through their registered agent?
Yes, ma'am, that's correct.
All right. All right, so the Meyer Enterprises have not responded. They were properly served through the registered agent. No attorney has made an appearance on behalf of Meyer Enterprises here as required in state court. Therefore, I'll hear from Ms. Reeves on HMI. And is it liquidated damages or unliquidated?
It's half and half, Your Honor. We've got liquidated damages pursuant to, if I may screen share our complaint.
Yeah, we'll go ahead and at this time, if you have a witness, let's swear him in and we'll go ahead and present the damage.
Well, the contract damages are liquidated. Those are in our lease ledger, which is a business record. We can also lay foundation, but that's attached to the complaint, business record, line items. But we're also seeking our actual attorney's fees. So I would have to give the testimony about the attorney's fees that were incurred. So however Your Honor would like to proceed, I can share the exhibit with the liquidated damages and go through the attorney's fees. And if you have any questions, we've got me for fees and we've got a client witness.
Well, first, let me understand what kind of contract is it for the record, and then let me know what you're claiming as far as liquidated damages.
Yes, Your Honor. This is a commercial lease agreement. The lease had not yet expired. We were able to get the property back. Nothing as exciting as the last case that Your Honor heard. Pretty garden variety. In fact, I think the tenant ended up surrendering. And so once we got the space back, we were able to get a replacement tenant. And so this is just a collection action for the past due rent and then a few repair costs. And there are a few attorney's fees on the lease ledger. And we filed this complaint back in February 23rd of this year. The registered agent was served February 27th of this year. No answer was filed. So we filed our motion for default judgment and our Rule 15 certification back on April 22nd of this year. And of course, by not answering, they've admitted all of our allegations in the complaint. The damages that we're seeking, as I said, those are pursuant to the lease ledger, which are undue rent and a few repair items, the total amount, and there's roughly $4,000 of attorney's fees. We're certainly not trying to double dip on those. But the total there is $141,163.13. And again, that's pursuant to our lease ledger, which was exhibit, I believe it's F to our complaint.
Okay.
Check on that. And then in addition to and I have that exact number, in addition to the $4,200.21 of fees, those ran through April of last year that are on the lease ledger. When we filed our motion for default judgment, we'd incurred an additional amount of $6,642.39. And then that was when we filed the motion for default judgment, Your Honor.
Mm-hmm.
It did not include the cost of serving the defendant with our motion for default judgment, preparing for the hearing today, or bench trial today, rather. So we've got a few more entries on our billing records in the amount of $3,495. And so the fees are $10,137.39. That does not include the amounts that are also already reflected on the ledger. And then the lease ledger amount is $141,163.13 for a total.
Are court costs included in the 10,000?
Yes, Your Honor. Our filing fees are in the billing report. Yes, Your Honor.
Okay. So go ahead, your total.
The total, Judge, is $151,300.52.
All right. All right. So Meyer Enterprises, Inc. served through their registered agent, failed to file an answer in this case. The company was never represented by an attorney of record, and the company is in default. Liquidated damages in this case stem from the contract for the lease. There's no possession as the premises were previously surrendered. The liquidated damages have been testified to and are in an affidavit as $141,163.13. Cost associated with the action came to $10,137.39. The plaintiff is seeking a judgment in the amount of $151,300 plus 52 cents. The court will grant that. Ms. Reeves, if you will get Ms. Powell, if you have not already gotten her an updated order, if you'll get her an order for that amount, for judgment in that amount, and just don't put proposed order, because proposed, I just got to wipe that out anyway. So, all right.
Understood. Okay, we will get that prepared. And may I ask Ms. Powell in the chat box for the best email address for her?
Sure. Definitely. Ms. Powell, if you'll just chat her your email address. All right.
Okay. Thank you, Judge. I will do that. And then if I may be excused after I get Ms. Powell's email address.
Yes, ma'am. All
okay,
right.
Thank you very much, Your Honor. Next
is the credit union loan. It cuts off, but the credit union loan represented by Christy Williams versus Aditya Gajar.
Good afternoon, Your Honor. Alex Capers on behalf of the Credit Union Loan Source.
Okay. All right. And Mr. Gajar?
You're Miss.
All right. So did Mr. Gajar file an answer in this case? Is my understanding.
Yes, Your Honor. So this matter was originally set after the court denied plaintiff's motion for summary judgment. Plaintiff then obtained additional evidence and filed a renewed motion for summary judgment. I did request from your staff attorney to be excused to give the defendant the statutory amount of time to provide a response. However, I was advised that I should show up to court today and make that request on the record. There was additional evidence submitted in response to specifically what the court denied in its order.
All right. And I think the reason I asked that is because I'm not always sure with a pro se litigant if they understand why I'm doing something. So sometimes when you have something especially like a motion for summary judgment that they might not understand that they can respond to, I'll bring it in. So Mr. Gajar, did you have the opportunity to see that the plaintiff has updated their information and their filings so that they included additional information?
No, ma'am, I haven't seen anything.
Okay. It was electronically filed. Is that correct, ma'am?
Yes, Your Honor, and it was also mailed. However, the mail is really slow right now.
Okay. So, Mr. Gajar, can you tell me I guess the street name that you would have mailed it to, Ms. Capers? No other information, just the street name?
McClure Woods Drive.
All right, Mr. Gajar, is that where you receive mail?
McClure Woods Drive? Yes, ma'am.
Okay, so I don't want to expose your address, but I anticipate that the mail service being what it is, you'll receive very soon the pleadings that Ms. Capers has filed with the court, and you have the opportunity to review those. You also have the opportunity to file a response to those. Once you have reviewed them, you can do so on your own, or you can do so with an attorney. I'm not able to advise you as to what your response needs to look like, or what needs to be in your response. That is up to you. But once you'll have 30 days from the date it is filed. So whatever the file stamp is from the clerk's office, which should be on the first page of the document, then you'll have 30 days from that date to file a response, which the court will consider both responses. Now, for a motion for summary judgment, you can ask for a hearing, but I can also make the decision based on what is filed, okay? So if you plan on filing something, just make sure you do it within the 30 days. If I'm going to set another hearing, I'll go ahead and give you notice after I receive your response, all right? Yeah, or after 30 days. So you get 30 days, or after 30 days has elapsed and you have not responded, then I'm going to go ahead and move forward. Okay?
I had a question.
Yes, sir.
So, do you know what's the new thing that's been added? Because
I do not. I haven't read it myself yet.
Okay.
So I generally don't, I generally wait until I have them both in front of me. If I'm going to get a response from the other side, then I'll wait the time that you have to respond. And once you respond, I can look at them both at the same time. If there's no response, then I'll read it after the 30 days has elapsed.
Okay, so I should just look for my mail, I guess. I'm going to receive something from it.
Yeah. All right.
And that is different from the stuff which you can send.
Yeah, initially the first filing, there was a defect that I asked for additional information. It might not have been a defect, but there was information that the court needed in order to make a sound decision. And so once they have amended their filing, you have the right to review it and then file something if you choose to. So that is what it is. I can't tell you just from talking to you right now, unless I pull up everything, what the differences are.
Okay.
And I try not to, and just to be honest, I try not to look at things ahead of time, because I don't want to form an opinion or say I like this particular argument because they've already filed it, until I get the opportunity to hear the response, if there is a response.
Yeah. Yeah, I mean, the only reason I'm asking is because I'm doing this by myself. I don't have an attorney, so I'm just trying to understand what.
I got you, and as I said,
that's all I'm just trying to.
I will explain as much as I can. I cannot assist you in making decisions, but I will explain the procedure and the timing as much as possible.
I understand. Yes.
All right. So this will be reset after the time has elapsed for both the response that may happen with this case. All right. So we'll give you notice, Mr. Gajar, if the court is going to set another hearing. Okay.
Okay. Yeah. I mean, I'm pretty straightforward. What I said is what I'm at. I have nothing else to add.
Okay. I got you. Thank you.
Thank you.
Anything else on that case, Ms. Capers?
No, Your Honor.
All right. So Mr. Gajar, you're free to go if you wish. The next
Thank you.
case
Thank you
is,
very much.
you're welcome. The Credit Union Loan Source versus Cornelius Austin.
And I'm
Mr.
here on that
Austin.
case as well.
All right. So Mr. Austin, let's see, this is a post-judgment proceeding. So there's been judgment in this case. And what are we seeking, Ms. Capers?
Your Honor, the defendant has filed a motion to vacate the judgment. Again, I believe it was already ruled upon. However, there was a new one filed. We filed a response. So I believe we're just here to, if the court has any additional questions related to the filings. But we're here on defendant's motion to vacate and set aside the default judgment order.
Okay, 1 second. All right. So, sir, this is about bankruptcy. So tell me why you believe that the case should be the judgment should be vacated. Okay, well, first, Ms. Capers, I issued the judgment, correct?
Yes, Your Honor, and I believe Your Honor also denied the previous motion to vacate in 2022.
The reason I ask is because I know that a lot of things happen post-judgment, and sometimes they're filed before a different judge, but I generally don't disturb a judgment that's been issued by another. There's very few, there's almost no instance where I can disturb a judgment from another judge. And so this was my judgment. I've already ruled on the motion to vacate initially. Mr. Austin, you're bringing this based on a bankruptcy. So tell me why the bankruptcy should have affected my judgment.
I feel I shouldn't have to pay the whole full loan amount. The vehicle was stolen off my property in the hands of their third party collection for turning
So
in the
by
property.
stolen, you mean repossessed?
No, I was turning in my vehicle. I was filing bankruptcy. That's part of the bankruptcy, was to turn in my vehicle.
Okay.
Credit Union Loan Source, they knew of the agreement. They approved on the agreement. They hired, I forgot what company, to come get the car. He gave me the directions on what to do, leave the keys in the car. They come get it in the morning.
Okay. All right. But
by my understanding,
did you include this judgment in your bankruptcy?
Yes. Everything's bankruptcy was the reason why I turned in the car. I went through 3 contracts for jobs and was laid off. This is right before COVID.
I got you, Mr. Austin. Let me just explain some things because it can seem pretty heartless when the court acts in a certain way. But number one, as long as the bankruptcy came after the judgment, then the fact that you filed
bankruptcy was before the judgment. My bankruptcy is the reason why I was turning in the car.
Okay, what date did you file bankruptcy?
Knew that.
Okay, hold on. What date did you file bankruptcy?
I filed bankruptcy on what is notice bankruptcy filing. This is 12/13/2019.
Okay. And was the bankruptcy discharged, or how did the bankruptcy conclude?
Bankruptcy was dismissed because my car was taken. It was not received by the Credit Union Loan Source. That was part of the agreement.
When was the bankruptcy dismissed?
This is April 14th, 2020. Yeah.
Okay. And so based on the case number on this case wasn't filed until 2024 is what I'm understanding. Is that correct, Ms. Capers?
No, Your Honor. I believe the case number was 2021. However, the court issued a new case number for the purpose of this particular motion. Something about it being filed after a certain time frame, the court had to issue a new case number. But the original court case number was 2021, which was also after the bankruptcy was dismissed.
Yeah, Mr. Austin, yeah, the bankruptcy. So the bankruptcy wouldn't have affected this.
No, the bankruptcy was before me turning the car. I had to go through the police report. I was talking with Credit Union Loan Source, the police during the year. This is COVID year. I've been up to the police a few times asking them about the vehicle. If they find the vehicle, he says no. If we haven't found anything in 2 weeks, it's probably gone. That's what I was told. So I had to wait. And then when the car wasn't received, I talked with the bank and I don't know what company they sent to come get it. It took 4 months. By the time, March hit 2020, everything was shut down. I lost 3 jobs during that time frame still trying to find a car. Nothing. So that's why I was dismissed right before that date on that time. Credit Union Loan Source knew the bankruptcy filing. That's the reason why I had to turn in the car.
Okay. When there's a bankruptcy filed, if my case is already pending, a case before me is already pending, and then a person files bankruptcy while my case is pending, I am required to stop everything until the bankruptcy is decided, whether it's dismissed or whether there's a final judgment for the bankruptcy. I'm required to stop all action. In this case, your bankruptcy started in 2019 and ended in 2020. Nothing regarding the bankruptcy would have affected a case filed before me in 2021. And so the bankruptcy in this situation does not affect this case in any way. Okay. So with that being said, there's no reason to vacate the order. Additionally, you keep telling me about the car being stolen or taken back. If the car
they found the vehicle.
Hold on. If the car is stolen, then if insurance doesn't cover it and pay the car off, then
I didn't have insurance at the time. I had no job.
Okay,
I got insurance off.
Mr. Austin, can I just explain? Because whether they knew it or not doesn't matter. You still owe it. I get
I would
that
like for it to vacate the default and then pay what would the value of the car would have been when they turned it in. They found it somewhere in Forest Park, and they sent me a letter talking about they auctioned it off. I never seen what the car looked afterwards. I couldn't get through the whatever shop it was at. The time I'm still coming off of COVID, so I'm paying back other creditors and couldn't pay for a vehicle as in
I'm just letting you finish.
Oh, paying for the vehicle that was in whatever impound, wherever it was.
Okay. So
that's why I brought up the bankruptcy, because that's the reason why. Like they knew everything step of the way. I wasn't shying from them. I did not run from them. I did my police report like I was supposed to, and would talk with them every step of the way. And every little 6 months, they come back with something new. So I don't have to vacate all 29, but bring it down to whatever the value of the car was in that nature, because I feel that's just.
Okay. So, Mr. Austin, hardship is not a legal basis for a company to not collect on what is owed. If you buy a car and you stop paying for that car, even if you turn that car back in, they are still entitled to whatever is left after they have either resold it or gotten salvage value out of it. So that's number one. So they can get a judgment if you stop paying. Whether you got bankruptcy, as long as the bankruptcy was discharged or dismissed prior to them filing, that doesn't matter. If you stop paying, hardship, COVID, all of those things that would tug at my heartstrings, is not a legal defense to your owing a judgment. Okay.
But I did
So,
stop because I had to turn the vehicle in. That's what made me stop.
okay, that's another thing. A lot of people, for some reason, think that when they turn the vehicle in, that they no longer owe anything. And that's
Oh,
not.
I'm not dumb to that. I know that. That's why I was asking. So whatever the value of the car was, to turn it, to make my payments from there instead of paying a full 29,000 when the car is not worth that much. I had the car 4 years.
Okay. And the other thing is, if you did not answer the case when it was filed, you have 30 days to answer. If you you have 15 more days to do what they call open default, which means you pay a fee and the court can allow you to answer even though it's late. After that, there's no way to answer or open default unless
Did
there's
answer, and I was late. Didn't know anything about a 15-day paying money because I asked the lawyer. He said, "Oh, you still have time to respond." I was not trying to not answer. I was looking for legal counsel on this case.
I got you. But we're at the post-judgment proceeding, which means I've already issued a judgment based on
But this is
what
what I said
happened.
in the first judgment. Try to seek legal counsel. He said I have time to respond. So I'm going off of a legal counsel.
Okay.
I'm not a lawyer, so I don't know the law on anything like that. That's why I responded, and then I got the default. If I known I had to pay extra money, then I would have do my due diligence more. But yeah.
All right. Anything else, sir? Nothing you said so far is legal basis for me to vacate my order.
So there's nothing you could do.
No, sir.
So I'll just have to file again later.
File what? It doesn't matter how many times you file, sir. The case is always going to be mine. And if there's no legal basis for me to vacate, then it's not going to happen.
Okay.
This I will tell you though, if somebody shows up, and I say this for everybody's hearing, if somebody shows up in a uniform, a marshal or a sheriff, and they have paperwork on that paperwork on the front of it, on the summons part of it, it's going to tell you how much time you have to answer the case. If you don't read it and pay attention to it, we'll take an answer on the back of a napkin, but you got to answer. And it gives you
Did
the amount
answer,
of
this
time.
wasn't a timely matter.
But it
I
has
was
to
the
be
one at the
time.
house who picked up that notice anyway.
It has to be timely, sir. That's the whole thing. That's why we tell you on the summons the timing for this. Okay.
Okay.
Thank you, sir. All right.
Thank
So the motion to vacate is denied at this time.
Thank you, Your Honor. May we be excused?
You may.
Thank you. Have a great day.
You too. All right. Clayton County versus Daquan Flournoy.
Good afternoon, Your Honor. Deanna Smith here for the plaintiff.
Good
I have
afternoon.
Rick DeTroya as my witness today.
Okay.
Rick, can you turn your mic on and your video on?
Mr. DeTroya.
Let me see if I need to call him.
Okay.
So the court granted a motion for summary or motion for default as to liability in this case on August 30th of this month. We're just here for a damages hearing. I'm going to mute myself and give Rick a call real quick.
Okay, thank you.
Your Honor, may I interrupt while counsel is reaching her client just to confirm that my case is in fact on this calendar?
Sure, Mr. Gill.
Uh,
Which case is yours? This would
Gresham
be,
versus Green?
yes, we'll
Okay.
be getting to that. This is a default. Thank you for your patience. I know you've been waiting for a while, but we'll be right to you. And just think of all the hours you build while you've been sitting here listening to my dulcet tones.
If only that was true, that would give me some measure of comfort.
I'm sorry, Mr. Gill. We move as fast as we can, but I believe in everybody getting a full and fair hearing, and I'd have to do a lot of explaining on cases where there's pro se litigants.
I certainly understand. I'll continue to wait. Thank you.
Right. Thank you, sir. All right, Ms. Smith. We ready, Ms. Smith? All right. So, Mr. Gill, you might be up. Oh, Ms. Smith, is Mr. Detroit? Ms. Smith? Okay, she can't hear me. All right. So the state of the Gresham, the estate versus Candace Green. Is there here anyone here on behalf of the estate?
I don't see anyone.
Nope. And so this is post-judgment proceeding. What have you all come before the court for in this case, Mr. Gill?
Actually, it's not, Your Honor, and that is one point to highlight. This is a refiled action of a voluntarily dismissed car wreck suit.
Okay.
So it's not a post-judgment because we haven't had a judgment.
All right.
Dismissed without prejudice last December. Dismissed without prejudice last June. Timely refiled last December. No service as of today. That is the basis for my motion to dismiss. And if Your Honor recalls, this is an almost 10-year-old car wreck. We were going to try this case back in the winter of 2018. It got continued. Mr. Gresham eventually passed away. There was an order stipulating the deadline to substitute the proper plaintiff. That didn't happen. Refiled motion to dismiss. The court denied it, told plaintiff to just provide an update. There were a few appearances on the pretrial calendar in 2023, culminating with plaintiff dismissing it in June, refiled in December, no service as of today. I think our legal position is set out in our motion, which is this is a refiled action. Everything starts new.
We're well past the statute of limitations for the issue to relate back, correct?
I would say so, Your Honor. Yes.
All right. And have you had any contact with Mr. Jones since the action was refiled?
Not for lack of trying, but no.
All right.
Emails.
So this case will be dismissed for want of prosecution. If you send me an order, I'll sign it.
Will do. Thank you, Your Honor.
Thank you, and thank you for your patience.
Have a great day.
All right, you too. All right, so I'm not sure what happened with Miss Smith. I don't know if she could hear me or what was going on.
While we wait on her, Judge, Lauren should have walked down some sentencing dismissal she needs you to sign.
Okay, let me go look.
Okay,
I was going to wait until we were done with this, but I can bring them in now.
Yeah, come on, bring them in for me. Ms. Smith, are you ready? Ms. Smith?
We have some technical difficulties. He's not getting, he's in the Zoom hearing, but he can't manage to unmute or turn his camera on. He's just gotten someone into his office.
Hold on.
I'm sorry?
Hold on. I sent him a message. This usually helps. I don't know. Can he sign on another device?
Okay, let me check.
Is he on his phone? Yeah, let him sign on another device. It doesn't have to be a computer. It can be a phone. It can be an iPad.
Into anything, even with the iPad.
Miss,
This
okay.
is a technical issue. His computer has stopped, he can't see his mouse. It's not clicking on anything in the Zoom meeting to where he can't even close out and re-log in. Is there any way to boot him out and have him log back in?
If I boot him out, he won't be able to get back in today. Does he have a phone or something? Does he have another device?
I do not believe he has a smartphone. He can call in, but I know to testify there needs to be video and audio capability.
Right.
The best.
Did you file affidavits in this case?
We did file an affidavit, and
Is
if
it,
the defendant is not here, I would just move to reconsider that with no one here to object.
Okay, then the court will base its decision on the affidavits filed with the court. What's the amount that you're seeking in total?
We're seeking $9,156.54 in principal. We're also seeking $1,200 in attorney's fees. I can testify as to that. Right now, my time on this case took approximately 4 hours. $300 an hour is reasonable. I've had this case since its inception. We did ask for attorney's fees in paragraph 5 of the original complaint, and we're arguing the defendant has been stubbornly litigious when no bona fide controversy exists. We're also asking for court costs the amount of $251.05. I did send Ms. Powell a proposed order in Word format that can be edited with those numbers.
All right, well, we'll get it done. Thank you so much.
Thank you. I appreciate your patience and the tough hearings today.
Yeah, it's been a couple of them. That's usually what happens on Civil Day. All right, thank you so much.
Thank you. May we please be excused, and I'm assuming he'll get kicked off when you end the Zoom session.
Yeah, he will if he can reset everything.
Perfect. Thank you so much.
No problem. All right, thank you all.